That matter wherein that compensation. Too delayed.
So we have to find a reply. The side without out of
Let his affidavit come on record. The learned counsel for the parties, item number 55. Pray that they be given further 2 weeks' time to complete their pleadings in the matter. Also, prayer accepted. Registry to list this matter again after 2 weeks on a date to be fixed by it. Before the next date of listing, the parties shall invariably bring on record their pleadings. Full stop. That is always open to you. Let the affidavit come in record. We will do the needful.
Please, Your Lordship. Item 14, we have filed
14.
additional affidavit.
Item
Yes,
number?
that may be called for 14, Lodge.
That
Tender, Lordship.
tender. That 52
Reply has been.
mahals, one mahal got closed. You get it.
And one more prayer, Lordship. Item 69, Lordship.
60?
69.
Hmm.
It's here, Lordship, limitation of filing inappropriate forum has already been seized, Lordship. So may I pray that I may be.
Madam, this is a case wherein you are claiming the benefits under a PA scheme.
We need to approach the appropriate forum, Lordship.
No, not the appropriate forum, madam. There is nothing on record to show that the man died because of an accident. It's a normal death. How will you be covered by a PA scheme then? Let the matter reach. You make your submissions. 20. Allowed to? Already revived. Interim order. Mr. J.P. Moore, learned counsel for the petitioner, submits that the petitioner has been given his relief in the matter and accordingly prays that the matter be permitted to be withdrawn. Also, prayer accepted. The writ petition stands dismissed on withdrawal. Mr. Moore, you were supposed to file an affidavit, file a written argument in item number 1, Mr. Chetia, but you have not filed it. Okay, when the matter is called up. No, it's okay. When the matter is called up. Yes.
Lordship, I beg to mention item number
50?
54. Lordship, Bank's senior counsel will advance his argument in this matter. He is out of station. Lordship, I am seeking at least 1 week of time.
Madam, what is here left? What can this court do here? It's a transfer of share. The procedure is by the general committee, it has to be done. All the other siblings said the respondent will have it. Now, how can we come in here?
The mother.
You go before the civil court, have it resolved there. This cannot be done here.
Kindly give us one date, Lordship.
On the prayer of a prayer is made on behalf of Mr. D.C.K. Hajorika for an adjournment in the matter today on account of personal inconvenience. Prayer accepted. A registry to list this matter again on 21/8/2025 by slip query. 21/8.
Nice.
Yes, Mr. Borwa. His case is that the director is being proceeded against, not the company. What is your stand on that? You are filing the affidavit today. Let him come. Mr. H. Borwa, learned standing counsel, finance and taxation department submits that the affidavit on behalf of the respondents represented by him is being filed today. First of the registry to list this matter again on 1/9/2025. In the meantime, the petitioner is at liberty to bring on record his rejoinder to the affidavit filed by the respondents, ipso advised, ipso advised. Obligement.
May I please, Your Lordship? In item number 77,
77.
IA for correction of the cost title. That may be taken with the main writ petition.
Madam, we will have to hear this matter today. You are against an order of an MSME court, tribunal. And that tribunal is not situated in Assam.
Yes.
It's beyond my jurisdiction. How can I entertain that challenge? This court cannot entertain that challenge. It's beyond my jurisdiction. 227, only the tribunals within the jurisdiction of this court.
In this main writ petition, respondent number 1 and 5 notice not served. That's why.
Fine, forget it. We will hear the matter. You satisfy me on this point. Let the matter be called up.
May it please your lordship, I beg to mention item number 71, lordship. With mention from the other side, the matter may be adjourned for the day, lordship.
Why?
Item number 71.
No, rejected. Argue. It's only the apportionment of the compensation. What this court will do, there is a procedure prescribed already. Go under that. Let the matter be called up.
May I please your lordship? Lordship, I beg to mention item number 62, lordship.
62.
Yes, lordship. In this matter, we are supposed to file affidavit, lordship. But the affidavit couldn't file
Affidavit by?
affidavit by respondent number 4, lordship. Lordship, we are filing the affidavit today itself, lordship. So matter may be
You were granted enough time for this.
some personal difficulty. Couldn't file. So we are filing today itself.
Who is for the petitioner? You are for the, any objection?
Last opportunity
Was granted. Let the matter be called up.
Yes, lordship.
Yes. 50?
I mean, not on this day, but some other day. Mr.
Why?
is out of state.
Mr. Doctor is out of station. Have you taken the consent of the petitioner? No, you take the consent. It's a contested matter. Take your consent, then come and reiterate your pay when the matter is called up. Yes. Thank you.
May please your lordship. Be allowed to submit it.
Have I prevented you? Please.
It is not a dispute, land dispute matter, your lordship. But the thing is, I sold I had 3 katas of land. I sold 1.5 kata to a purchaser.
But he got his name meted in the whole, for the whole plot of land, 3 kata.
I didn't blame. That's why I didn't go to the learned civil, process civil court. Actually, I think a record correction has to be required. My unsold part of the land, the dark number and pata number went to the purchasers 1.5. So when I went to pay the revenue for the remaining unsold part of the land, the Moza told me to approach the.
What have they done after your complaint petition was
No, they
received?
didn't do anything. They have all the excuses.
Yes.
Inaction on the part of the administration matter. It's just a procedural lapse.
Whatever it is, he has drawn a complaint, you will have to take it to its logical conclusion.
Let the matter be disposed.
Have your instructions.
Let the matter be disposed of, your lordship.
No,
My limited.
we want to have the instructions first. Mr. N. Das, learned government advocate, appearing for the respondents number 1, 2, 3. For the respondents number 1 to 5, submits that he be granted
1, 3, 4, 5.
1, 3, 4, and 5. Submits that he be granted time till 5/9/2025 to complete his instructions in the matter. On the next date of listing, Mr. Das shall apprise this court as to the steps taken by the respondent authorities in pursuance to receipt of the complaint petitions dated 24/2/2023 and 16/8/2023 from the petitioners herein. Also, further orders as would be mandated would be so passed upon receipt upon Mr. Das completing his instructions in the matter. Also, registered to list this matter again on 10/9/2025.
Highly obliged, Your Honor.
Supplementary list.
I thought there was a change of guard. Mr. Saraf, before we go into this thing, the money is already transferred according to that. That will be subject to the result of this.
My only difficulty is that this bank is ready to return the amount.
Fine, we'll do that. What I propose is, there are only 2 parties which primarily we'll have to hear for an interim order. That is the RBI and the ICICI Bank. RBI, you can take your steps through Mr. P. Hajurika. And with regard to ICICI Bank, kindly serve Dusty.
Justice, my application, whatever apprehension is that, they may not give the money to me. They may not give the money to me.
We will pass that order, get that person on record.
At least, my lord, otherwise, if the money is given back to the party in Bangladesh,
That order I cannot pass today here. The Bangladesh party, the bank would not be covered by my jurisdiction.
direction to Bangladesh Bank.
Hmm.
ICICI Bank to accept it and keep it in their account. Once the Bangladesh Bank gives it, let them keep it in their account and don't disperse me.
Okay.
And at least-
Considering the nature of the dispute raised in the present proceedings, the petitioner, you are appearing for respondent number 1.
1 and 2.
1 and 2. The respondent, the petitioner is directed to effect service of notice of the present writ petition upon the respondent number 3 through the Standing Counsel RBI, Mr. P. Hajurika. Mr. P. Hajurika is requested to receive the copy of the writ petition and also complete his instructions in the matter before the next date of listing. For so, the petitioner to effect service of notice upon the respondent number 4 by way of dusty service routed through the registry of this court. Steps for service be taken within a period of 2 working days from today. On effecting such service, the petitioner shall file an affidavit to that effect. Full stop. Mr. Dr. A.K. Saraf, Learned Counsel for the petitioner, has made a categorical submission that the bank in Bangladesh, which had remitted the payments receivable by the petitioner herein to the respondent number 4, is agreeable to refund the money, return back the amount which was sent back, which was remitted back by the respondent number 4 recently. Also, if the above be the position, the pendency of the present proceeding is not a bar to the respondent number 4 to receive the amount from the bank at Bangladesh, and the amount if so received shall be kept in a separate account and be not released to the petitioner until a petitioner pending further directions passed by this court. Full stop. Registry to list this matter again on Monday is a holiday, 27/8/2025.
So my only appearance in that, once the Bangladesh Bank gives me, then
Let them keep it. They have that Nostro account, they can keep it there, wherever they keep it. I know, I understand.
That is only
The only question here is because that Iran angle has come in.
the question.
That vehicle was that vessel was in Iran. So they have a doubt whether it is a transaction with Iran or with
The question is
UAE.
that with India, there is no sanction.
But they are an international bank.
Now the Russia, whatever imports and exports are done, there is a restriction. Iran also, the export is done. There is no under the Indian law.
There is no
There is
restriction.
no restriction.
We'll consider. Let them come. Oh, Mr. K. Gogoi, Learned Counsel, appears for the respondent number 1 and 2. We have not issued a notice in this matter. Let this.
Our part, our ruling.
Okay. Mr. Gogoi shall also, before the next date of listing, complete his instruction.
They are coming also.
After you get your policy in one place, shall also complete his instructions before the next date of listing. Mr. Chaudhary, here for what? Oh, it's coming. Yes.
Yes, my lord.
Who is appearing for the BTC? Not BTC.
On the last day, some B was.
You have said many things, but where is the material to show that there is an assurance? Because if you want to withdraw the writ petition, I'm permitting, but we'll not record all these things.
some applicants have decided to withdraw and other.
No. What about, yes.
Yes.
What about the others? How can you withdraw a writ petition when there are 17
17
petitioners?
Out of 17.
8 has come.
19.
We can't permit this. You will have to have the consent of the others also. You have not written anyway.
The persons who have already. by
That
filing
would be
this
a case of
case,
deletion of their name. We can understand. But withdrawal of the writ petition,
and
only
the
half-
petition has not been interested to be withdrawn by the other respondent.
then you
Uh,
file an
that is-
application for deletion of your name, not for withdrawal.
Whatever, maybe, my lord, that may be.
Mr.
Mr. M.D. M.S. Ali.
Mr. M.S. Ali, Learned Counsel, for the applicants, submit that he be permitted to withdraw the present interlocutory application with liberty to refile the same, praying for deletion of the names of the petitioners who do not wish to press the matter further. Prayer accepted. Interlocutory application stands dismissed on withdrawal with liberty as prayed for.
Ali, Ali.
Dr. Sarab, the respondents where you have given me your written argument, they were supposed to give it on 14th. It has not come on record. So they are submitting it today. Give a copy to Mr.
We have already filed.
Also,
I have nothing to add because whatever they may submit,
we have already.
the
Brought-
only thing below that they have also mentioned in their order
Hmm.
that there was a failure on the part of the SSC to disclose material facts, although that's not a condition.
That page you have shown me wherein you have given the details of the transactions involved.
Now,
The only question is whether it is a long-term capital gain or a short-term capital
so
gain.
that issue will be there,
Hmm.
but disclose material facts on that a decision I will place before also. Okay, I'm
Okay.
giving
A further decision.
the decision my lord, on that issue I found. Then what is the two and
Would you like to go through the written argument submitted?
don't think that they have repeated whatever is there. The also may see page 7. The last 8 or 10 lines, my lord.
Hmm.
The duty of the SSC, as you also got it, my lord.
The duty of the assessor.
The duty of the SSC in any case does not extend beyond making a full and final disclosure of the facts. Once he has done that, his duty ends. It is for the income tax officer to draw the correct inferences from the primary facts. It is no responsibility of the SSC to advise the income tax officer with regard to the inferences which he should have drawn from the primary facts. If the income tax officer draws an inference which appears subsequently to be to erroneous, may change your opinion with regard to that cannot have so and so. I have disclosed.
That example you gave me, that somebody here doing a book transaction, whether he is also responsible, that will be verified by this.
One last paragraph, my lord.
Huh.
Last page, page 10.
Hmm.
The last paragraph, my lord. The 4 or 5 lines.
Yes, so far.
It has been said that the taxes are the price.
That are the price we pay for civilization.
They are not conversant. Provisions of law.
Okay.
And the result is that, my lord, cannot say that this is a revenue matter if they are not conversant.
Hmm.
While Lord invoking the powers, the revenue has to suffer. They themselves are not aware that whether it is a 147A, whether it comes to which provision, somewhere they are saying non-disclosure, somebody they are saying something.
Also, today, the matter was fixed for delivery of orders and the respondents were to file their written arguments in the matter on 14/8/2025. Also, Mr. S. Chetia, Learned Standing Counsel, Income Tax Department, submits that on account of a personal inconvenience, he could not file the written arguments on 14/8/2025. Also, Mr. Saraf has further placed on record a decision relied upon by him in support of his submissions, which is also taken on record. Also, in view of the above position, the delivery of order is deferred today, and the registry is directed to list this matter again on Hundina Seolok Khali 4/5 4/9. I got 9 4/9/2025 for delivery of orders. I'll go through it in a minute. And if I have any query before that, I'll list them.
Purely.
There is a contempt matter arising out of this proceeding. That is contempt case number 295 of 25. It is fixed on Friday next. May I pray, my lord, this matter may come along with the contempt on 20.
Okay, okay. No issue. But
Actually, my lord, the impleadment of those person is relevant as would be evident from the order passed in the contempt proceeding.
okay. They have done it in the eastern side. Southern side, there is
To keep it open.
open. But how do you correlate that with para 8 of your
Actually, my
agreement?
lord, the impleadment is on in respect of the person who owned that kiosk.
Huh.
He is one gentleman called Mohammed.
Ali, some Ali.
Now, my lord, and another, now if your lordship kindly comes to the petition, now this is presently what is happening. Case number,
What happened to the trial?
please come
suit?
to page 20, my lord.
Page 20 of
Yes,
the writ
19
petition.
and 20.
Of the writ petition.
Yes.
Yes.
This, sorry, that contempt petition is not
Okay,
before your lordship. That is
okay, we'll have it on
Yes,
together.
Friday.
Mr. K.N. Chaudhary, Learned Senior Counsel, appearing for the petitioner, submits that a contempt matter emanating from the orders, emanating from the present proceedings is directed to be listed by this court on
Friday, my lord, 22.
22/8/2025. Accordingly, he submits that the present writ petition be also taken up along with the said contempt petition. Also, prayer is not objected to by the learned counsel for the respondents. Also, accordingly, the registry to list this matter again. Contempt is there on 22nd. If you have any problem, take it on 27 on that, because there is already a direction. On 22nd, the contempt should be listed.
Corporation has carried out the order. We have no.
Partly.
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 That kiosk has been removed.
22nd, if you have any problem, make a mention on that day. We'll accommodate. On 22/8/2025, along with contempt petition number
295 of
295 of
2020.
2025. But Mr. Chaudhary,
Sure.
one factor, just for my understanding, what will happen to that agreement between you and the respondent, wherein in para 8, that space you cannot use?
No, it is not identified. That will kindly visualize a situation.
Okay.
I've been let out a room and in front of and somebody else will do the business. I can appreciate, my lord, somebody squatting in the floor, a footpath.
But it's not in the footpath. It's that space
Earlier,
between the footpath and the.
And now they have set up a temporary thing, my lord.
What happened to the civil titles? Pending.
That is their suit.
Their suit for eviction.
Yes.
Okay, fine.
So there they cannot get an injunction, therefore they have taken law on.
Law.
So what sort of injunction?
Otherwise, it's too factual.
On 22nd.
It is your lordship. Lordship, implement of parties. Lordship will find the name of the new incumbent at page number.
But Mr. H. Patala, Learned Counsel for the petitioner. Also, the petitioner, by way of instituting the present proceeding, has sought to, as prayed for, impleading, page 4. So and so, page 4, A to A. as a respondent number 9 in the connected contempt petition being COP bracketed, COPC bracket, contempt case number 278 of 2019. I have perused the contentions raised in the present interlocutory application and also upon hearing, and also heard Mr. H. Batala, learned counsel for the applicant. So on a consideration of the same, this court is of the considered view that the opposite party number 1, who is sought to be impleaded as a respondent number 7 in the connected contempt petition, is the authority who would now be required to implement the directions passed by this court. Accordingly, it is directed that the opposite party number 1 herein be impleaded as a respondent number 7 in the connected contempt petition. So with the above observations and directions, the present interlocutory application stands disposed of. Yet, Likha, in view of the order passed today in IAC 2608-2025, ACO A2A is impleaded as a respondent number 7 in the present proceedings. Petitioner to file an amended cause title within 2 working days from today. On filing of the amended cause title, petitioner to take steps for service of notice upon the newly impleaded respondent number 7 by registered post with AD. Steps within 3 days thereafter. Steps within 3 days from the date of filing of the amended cause title. Registry to list this matter again after 4 weeks. I had to dispose of. Right. Yes, Mr. Vachaji, what has happened? PPO issued. Great. This is called promptness. This is what we expect from an organization like yours.
Because of the court.
Also, Mr. D. Bhachaja, learned Standing Counsel, IA and AD. That's the correct designation. Standing Counsel, IA and AD submits that the Office of the Accountant General, bracketed ANE Assam, on receipt of the both halves of the PPO issued in respect of the father of the petitioner herein, has issued a family pension payment order in respect of the petitioner herein on 8/8/2025. Full stop. The issue raised in the present petition is to the effect that the petitioner herein was not being authorized her due family pension after the death of her mother, who was a family pensioner. Also, with the issuance of the family pension payment order, FPPO, with the issuance of the said FPPO dated 8/8/2025, the grievance of the petitioner herein stands redressed. Full stop. There is no further live issue to be decided to be adjudicated by this court in the matter, and accordingly, the present petition stands closed. Also, the authorities are now required to comply, to execute the said FPPO shall do the needful in the matter expeditiously, ensuring that the petitioner is in receipt of her family pension in terms of the said FPPO dated 8/8/2025. A copy of the FPPO along with the communication dated 8/12/2025 furnished by Mr. D. Bhacharia is clipped on record and marked as X.
Only one thing, my lord. We applied it for, my lord, on 6/11/2023. So there is no area, my lord, rule clearly says, my lord, but from the date of application.
That you don't
That-
get it,
that
come
is-
back. That you don't get it, come back. That you don't get it, come back. Write to them, come back. We will see. But this was, you have got the elephant, you've got the elephant. Now how you buy the rope and all thing, whether you want a golden rope or a, that you come back. We'll,
Deeply obliged.
but this, thank Mr. Pachaja for that.
Grateful to your lordship, sir, especially. Deeply obliged, sir.
Senior is on legs, your lordship.
Okay, there was some report received by you.
That was.
I have given it back.
Because as per your lordship's earlier order,
Hmm.
how they have granted patta to the person concerned without demarcation of the land. Same, your lordship, same vicinity, and these are two neighbors. In my case, it was not considered. Itu tuh dia
Now, if you can settle that in a NK village with one, why not the petitioner?
That was the question, your LDC.
Why no reply on that? Because if you don't have a map, how did you make the settlement with Suren Talukdar?
That was the specific question.
You are for Prafulla Dotto.
Full lot of.
It was not, that query has been not replied back.
Why?
Only to the extent, my lord,
Why?
my letter is very specific regarding that. Beltola mother,
that is not a dispute.
Okay, okay.
What he has stated is not
But the
dispute.
learned counsel for the petitioners also heard
I'll get.
Mr. N. Das, learned counsel, learned government advocate appearing for the respondents. Mr. N. Das has placed on record instruction received by him on 18/7/2025 in pursuance to the queries raised by this court on
16/8/2025.
16/8/2024.
2024.
Full stop. It is on a perusal of the instructions as placed on record by Mr. N. Das, it is seen that the respondents have not made any contention with regard to the query raised by this court as to how the from the same DAG number, that is DAG number 100, the petitioner herein, petitioner in WPC number 4591/2016 was given a settlement, while the same is being denied to the petitioner in WPC number 7852/2018. Although the instruction revealed that both are in possession of land along with dwelling houses thereon. Also, Mr. Das, in view of the above position, submits that he would complete his instructions in the matter on the next date of listing. Accordingly, registry is directed to list this matter again on. Can you have it on Friday? On 3/9/2025. Also, in the event on the next date of listing, complete instructions with regard to all the queries raised by this court, while the order dated 16/8/2024 is not placed on record, comma, this court would be required, would consider passing orders directing the circular officer, Dispur Revenue Circle, to remain present on the same date for assisting this court for assisting this court, along with the records for assisting this court towards a disposal of the present petitions.
Can be, if possible, my letter dated 24/6 have specific.
That is up to you. Register to list this matter again on Kiman question 339 question.
39.
39. Okay.
Password.
Yes, Mr. Vachaji, you were supposed to receive instructions. Have you received your instructions? Huh? Mr. J. Hande, call him. This was the third order passed on the last date. So get him.
My lord. Mr.
Why?
Yes, Tapadar is dealing this case, my lord, due to some.
Okay, you are there. That is enough.
Myself.
You are there. When you are there, why should we have somebody else?
Earlier he went to.
Now, tell me, what is this grievance that you are raising? It's admittedly a forest land.
Yes, my lord.
Now you want a village for a particular community to be opened there. Forget it. Now, first and foremost, satisfy this court on one count. Your case is that you came to this land after being eroded by your lands were eroded in the earlier village. Which is that village? Where is that land erosion certificate?
Reading, my lord.
Map reading will come. But where is that village from where you came? Whether it is in India. Secondly, where is those displacement certificates? This forest was declared in 1915, right? And you are not a forest dweller. Scheduled tribes, protection of scheduled tribes and other forest dwellers. What is it called? The act? Scheduled tribes and other traditional forest dwellers, a recognition of forest rights, Act 2006. Now satisfy me as to how you come within the purview of this act. Sometime we'll grant you, no problem till 2 o'clock. This issue is there. You have made additional affidavits on that behalf.
Yes.
So tell me, you have cleared a portion of the land, right? And you are settled there. You have got nothing to do with the, be very careful in your answers. You have got nothing to do with the forest, right? You are only concerned with that land, parcel of land that you have cleared and you have occupied, right? How will this act come to your benefit? This is in relation to the other non-traditional forest dwellers who rely on the forest. There is nothing on record to show that you are relying on the forest for your livelihood. Your case is, this is a village which we have carved out, give it to us. And you take benefit of this. 2006.
Per para 7 of my additional affidavit.
I am having it. Now show me that you are a traditional forest dweller in terms of the provisions of this act.
For para 7,
I got it, para 7. Now read para 7 in the light of this act of 2006. come to the definition of other traditional forest dwellers in 2O. We got the act with you, 2006 Act.
Kindly 1 week only.
Good. Read that.
Other traditional forest dweller means any member or community who has for at least 3 generations prior to the 30th day of December 2005 primarily resided in and who depend on the forest
And who.
who depend
Now
on
show me from your pleading that and who is also satisfied with. Yes, Mr. Gogoi, what is your stand?
Yes.
You have not filed an affidavit, have you? Well, okay, your affidavit is on record.
They are saying that traditional forest, apart from forest, nothing can be seen in forest. And further, the Act as clearly says 3 generations prior to 1312.
In and who? In and who?
In and who?
In and who?
Who?
Depend. So who depend is not.
Is not wrong.
Okay.
And further, they have admitted that the encroachers are.
Was there an earlier writ petition filed by the before this goes?
Yes.
Where is that order? Is it on record?
yes, madam. Can you see page 36, madam.
11/6/2007. Okay, it is on record. 36.
Para, my lord, 5 and 47.
So after this order, have you taken it up on appeal? Have you filed an appeal against this order? Then how can this writ petition be maintainable actually?
There was a direction, my lord.
Fine, that is, direction is after the observation. We can't ignore the observation that you have got nothing to do here. We have got nothing to do. And they have passed orders. Okay, we'll not put Mr. Uddin to further trouble. Let Mr. Tapadar come. We will consider. Heard Mr. G. Uddin, Learned Counsel for the petitioner. You are only for 2 petitioners.
He was.
How is this division being done? 2 petitioners,
Actually, he was outside of, and that time, my lord.
Okay. Mr. G. Uddin, Learned Counsel for the petitioner submits that the arguing counsel, Mr. A.S. Tapadar, is not in a position to appear before this court as he is indisposed. Full stop. Mr. Uddin has made his submissions in the matter. However, he submits that further submissions in the matter would be made by Mr. A.S. Tapadar. Full stop. Mr. D. Gogoi, Learned Counsel for the Learned Standing Counsel, Forest Department is present. Full stop. R. Gogoi. Accordingly, registered to list this matter again on 2/9/2025 for further hearing. I think you will have to satisfy me on these points. Otherwise, we'll be our hands are tied.
15.
Why was there no representation, Mr. Sharma? Last date? Yes, the report is here. You give it to Mr.
6 petitioners, madam. Only 2 is allowed. The committee, madam, they consider.
Fine, that is different thing altogether. But they'll have to receive some compensation, adequate compensation here. Because their lives were made miserable by this. Literally. What we could gather from the materials already available on record. What is this report? Where is that report? Hmm. Eight?
Running page.
Okay, I missed this. There are 8 persons involved. 6. But 8 were had post-operative complications.
Oh, so the report, my lord, that where in the affidavit it says
13 got some.
my lord, all 13s were called. We tried to contact them. Out of them, my lord, only 5 were absent, 3 were present. Rest 5, my lord, they've absent.
matter.
It was this one honorable court.
Be that as it may, they have approached here. Okay, what do you propose to do? You propose to...
My lord, already, my lord, that some my lord, member from the finance department also in the committee.
Mr. B. Gogoi, Learned Counsel. Mr. Sharma, let him do that exercise. There we'll come in. I heard Mr. R. Sharma, Learned Senior Counsel, appearing for the petitioners. Also heard Mr. B. Gogoi, Learned Additional Advocate General, representing the respondents. Also, Mr. Gogoi submits that a committee is already constituted.
No,
That's what is.
Examination was considered.
Huh?
For medical
Okay. Submits that the medical examination report with regard to the grievance, with regard to the infections suffered by the, with regard to the loss of eyesight suffered by the petitioners in the above noted writ petition in pursuance to a cataract operation carried out in their case by the state doctors has already been received, and the same would now be considered by a committee to be constituted Where is that, along with that, I think it's here, that a finance commission member would also be involved. There was an order passed by this court.
21/4/25. Last in my lord 7.
21?
21st April.
Okay. In terms of the direction passed by this court-wide order dated 21/4/2025 in the present proceedings, Mr. Gogoi submits that the said committee would consider the matter and arrive at a due compensation, arrive at the amount which is now required to be paid to the petitioners and their
Any compensation.
arrived at with due compensation be paid to the petitioners and their legal heirs in the matter. So he submits that the said exercise would be completed within a period of 3 weeks from today. Also, this court at this stage would await the computation of compensation that is now required to be made by the state respondents in the matter, and thereafter would examine as to whether the same is adequate or not after hearing the parties to the proceeding. Full stop. Accordingly, the registry is directed to list those matters again on 10, or we'll have it on 15/9/2025, on which date Mr. Gogoi shall place on record the decision of the constituted committee with regard to the compensation that would now be required. And that has been assessed by the respondents to be paid to the petitioners in the above noted writ petitions. Petitioners oblique legal heirs in the legal heirs of the petitioners in the above noted writ petitions. Okay.
All right.
Your Lordship, affidavit not yet.
After some time.
Obliged, Lordship.
So as per the order dated 8/12/2020, they were supposed to file an affidavit, Lord.
Who should file?
The government side, Lordship.
Hmm.
Respondent number 4
Hmm.
and 6. Same has not been filed yet, Lord.
Yes. This has to be filed by PNRD only. So it is seen that the name of the Standing Council PNRD is not reflected in the cost list. Accordingly, there is no one representing the respondents number, the respondents in the matter. Respondents number 1 to 5 in the matter. Accordingly, the registry to list this matter again on 2/9/2025, reflecting the name of the Standing Council PNRD in the cause list for the respondents number 1 to 5.
There's an entry model of
Entry order, if any, to continue till the next date of listing.
11.
May I please? Is the case, my lord, the issuance of the notice by the Kaji was put under challenge, my lord. There's no.
But that notices have now gone and transformed itself into a divorce. Talake Hassan. 3. So why should we here? You go before the family court, assail that degree, assail that divorce degree, divorce.
Judgment, my lord.
See, Mr. Sikdar is very ready.
My lord, I may be.
You go before the tribunal. This is.
So there is a.
See, Hassan is not barred.
Hassan is not barred, my lord.
The issue there are judgments of this.
Judgment I have annexed, my lord.
But the factual context therein and the factual context herein are different. In one of the decisions, there was 2 talak namas issued. Third one did not come. In the other one, the very issue, it was by a private body, not a government registered. So the issue was whether a government private organization, a Kaji appointed by an NGO or a private organization, would be similar to a Kaji appointed under the 35 Act. This court found no. But therein also, the talak per se was left open to be assailed before the competent court.
My lord, the time consumed, my lord, that may be condoned, my lord.
That is up to, they can always do that.
Yes, my lord, I have already.
This is by that division bench, wherein that 2 talaks were issued. This is that writ court. Before the writ court, the question was there was 2 talaks issued. Third one did not come. Then it was contended that it is talak-e-Hasan, Hasan. This court said not doing. It cannot be construed. So it said go before the Mr. J.I. Borhuia, learned counsel for the petitioner, after attempting to argue the matter at some length, has submitted that he be granted liberty to approach the appropriate forum for assailing the divorce as pronounced in his case by the respondent number
Private respondent.
number 7. Also, in view of the above position, in view of the above prayer made by Mr. J.I. Borhuia, this court, without entering into the merits of the matter, requires the petitioner to approach the appropriate forum for annulment of the divorce as pronounced in her case by the private respondent number 7. Also, in the event any such proceeding is so instituted within a period of 1 month from today, the concerned court shall consider, for the purpose of condoning delay, the fact that the present proceedings was pending before this court with effect from 19/12/2018. Also, with the above observations and directions, the present writ petition stands dismissed on withdrawal with liberty as prayed for. Mr. A.R. Sigdar, learned counsel for the respondent number 7 is present.
Instead of dismissal, my lordship kindly use the word dispose of.
Same thing I have said.
Or closed one.
Doesn't make any difference. In another matter wherein this challenge was there, it was in relation to CRPF. See, there is another issue. This is an issue between you two. This writ court should not come in. There was another matter wherein the same issue had come up, but therein it was a deletion of her name from the service records of the husband in the CRPF. I said that is bad because it was literally talak-e-Hasan there also. I said that is bad because this issue came up only towards the fag end. There were many proceedings. This was never brought on record by the husband. But I said with regard to the decree, this court, hands off, you will have to go before the. So now I am emboldened by a decision of the division.
Lord, can I have the number, my lord?
You can keep this copy. Mr. Sigdar, with your.
I got the number from my
I
friend.
know that. I know that. Mr. Borhuia he knows everything.
Abdul Khalik, it has gone to Apex Court.
Apex Court, it is pending there. Notices have been issued only.
That Baharun by the.
No. I know that. I know that personally. So don't worry. Don't take the names. Names of the parties are not to be taken.
Sorry, my lord. Sorry. Extremely sorry. Look.
But therein there was an issue that there was. Well, no, you can keep it.
My lord, I know. I got it.
Keep it. You will use it. Why I said so?
My lord.
It's already here.
But unfortunately, the petitioner died on 29th of June to 2025. I may be allowed to substitute within 1 week, my lord. 2 weeks.
Mr. Counsel,
My lord.
this court is not advising, but there is a way out for you. Say this is a fraud committed in your account, but they have identified certain accounts to which your part of the money was, and those accounts are now under hold. You only got to do a thing is, you have to approach the jurisdictional court of Chief Judicial Magistrate, file an application for getting that money. An order would be passed and that money will be returned to your account, subject to certain undertakings to be given by you. That much only you got to do. The other part, we will see.
That is one of my prayer, my lord.
But you proceed, get that money.
But
at
that
least
is out of Assam, my lord.
wherever it is. They have branches here. You will have to go to the branch. You just go to anybody practicing in the CGM court, just have a discussion. This money can be brought back to you.
I'm on that process also.
You do that. Your name?
DK Nath.
DK Nath, learned counsel for the petitioner, submits that the petitioner during the pendency of the proceedings has passed on, on
29th of June.
29 June 29/6/2025. Accordingly, he submits that he be granted 2 weeks time to file an appropriate application for substituting the original petitioner with his legal heirs. Prayer is not objected to by the learned counsel for the respondents. Registry to list this matter again after 2 weeks, along with the interlocutory application undertaken to be filed today by the petitioner.
Right.
Please. Pursuant to proposals submitted by the circle officer as well as DC, they did sub-deputy collector, my lord, the lands allotted to the petitioner, each family 1 bigger land for homestead. Accordingly, they are now residing there by making their homes.
Allotted, was premium paid? Was it settled with you?
No.
Then
only allotment was given.
Only allotment.
Thereafter, they have filed application.
That
before
allotment will give you no right until and unless you pay the premium. Now the issue that comes up is,
my lord, premium will come there.
now the issue that comes up,
It settled thereafter.
oh,
After 3 years.
show me, where is that premium payment receipt? Where is that premium payment? Have you paid the premium on the land?
Not yet paid.
Then, now tell me, this land is VGR land. And you are not for a public purpose, it's a private purpose. Jaspal Singh, how can this be done?
Out of 104 bighas of land, 104 bighas of land, 90 bighas of land is government land, but not VGL land. Only 10 bighas land is VGL land. Your lords will find
But
that page, my lord.
here,
Page 13, my lord.
I'm sorry, there is an affidavit of 2020 by the Assistant Commissioner Sunitpur on behalf of the respondent number 3. In paragraph 4, there is a categorical statement. You have not denied it for the last 5 years.
My lord, kindly come to page 13, my lord.
No, come to this.
Silent.
Come
Out
to
of
this.
113 bighas of land, 94
Forget
bighas,
it.
one
Come
cut
to
and
page
5 lessons
2.
of land are government
Page
land.
2, page 2, para 4.
Yes, it has been stated here, my lord.
Then, what, I'll go by that.
Then, my lord, I will file a result.
5 years you have not filed. Why should I permit you?
Record is here, my lord. Original record is here, my lord.
Where?
Yes, page 13.
13, what is that?
Yes.
Read.
My lord.
Read.
Yes, my lord. চক্রবর্তী উপসমাহর্তা মহোদয় 9/10/90 তারিখৰ মৰ্মে আৰু 2091 প্ৰস্তাৱ মৰ্মে 21/12/2091 তাৰিখৰ নম্বৰ চিঠি মৰ্মে প্ৰস্তাৱসমূহ লোৱা হ'ল। উক্ত প্ৰস্তাৱ মৰ্মে ইয়াক তালিকাত উল্লেখ কৰা 114 বিঘা 14 জন গ্ৰাম্য প্ৰাৰ্থী ভূমি পৰিষদক তেওঁলোকৰ নামত বিসংগতি দেখুৱাই পৰিয়ালক মাটি বিভিন্ন গাঁৱত ইমান নম্বৰ নিম্ন ধৰণৰ বাছনি অনুযায়ী আবেদন নিৰ্মাণৰ বাবে 94 বিঘা 1 কঠা 5 লেচা চৰকাৰী জমি আৰু 10 বিঘা গোপাচাৰ মাটি, দিছ ইজ ভিজিএল লেণ্ড, গোপাচাৰ মাটি মুঠ 1104 বিঘা 1 কঠা 5 লেচা মাটি।
So show me that you have been settled with government land and not with the, what do you call that, VGL land. Show me from the pleading.
How I can
That you have to show me. You will have to make that allegation. They are very clear that this land covered by DAG number 151 and all the petitioners, the number 1 in page 12 is 327.
Yes.
That is a different land altogether. But from you, the petitioners are all 157. And 157 has been clearly stated to be a DAG which belongs to the government VGR land. We can't go a step further after Jaspal Singh. Yes, Mr. Sharma.
He has not denied the averments made by us in our affidavit.
No. 5 years you have not done it. We are not going to do it.
1 week, my lord.
Not even a day.
While the original record is saying that there is 90 out of 100 and.
Show me your statement to that effect in your writ petition, that you were settled with 157, which is government land, not VGR land. Just write 5-10 paragraphs, file a writ petition. That will be the end of the matter. I'll also write 2 orders, 2 lines, and I'll close the writ petition. Same thing. This submission of yours that you are now making, where is the basis in the writ petition?
Initially, my lord, allotment has been given to them. So subsequently,
Allotment,
as per land,
allotment
if
cannot be
at
done.
3 years is there, then they can.
No, I'm sorry.
They have the right
VGR land, we are not. The Supreme Court is very clear.
VGR land only 10 bigas, my lord.
Show me that you are outside that 10 bigas. There is no averment in your writ petition to that effect. And on the last date of listing, you have yourself said, don't send it to mediation because this is with regard to settlement of land with VGR land.
Last occasion, no, I never did it.
Okay, you did not do. But we are not going into it.
Then send it to the mediation, my lord.
No. Why should we?
Then no one, otherwise 1 week time,
No,
file a reply.
not even a day.
Why, my lord? Only for the ends of justice, my lord.
Ends of justice, you had this statement glaring at your face from 2020.
Not that, my lord, there is a very original record is with the petition, where specific stated that out of 104 bigas of land, 90 bigas of land are government land, and 10 bigas are VGR land.
We are concerned with DUG number 157. It says 157 VGR land. Finished. That's the end of the matter.
Only 1 week, my.
Show me the reason why you have not filed a reply for the last 5 years. You have wasted the time of this court. We have limited time. Now, I can give you an adjournment. No problem. Subject to payment of a cost.
Poor person, how it.
Person, the petitioner's counsel is not poor. We'll put it on the counsel. We'll put it on the counsel. You know what I used to call, you remember what I used to call you the other side. So, a landlord can always pay.
Poor people. Only 1 bigas of allotted.
Yes, Mr. Sharma, what to do?
Internet friend is relying on, their lordship, nowhere it is stated it is under DUG number so and so. Whether it is belongs to them or somebody else, how can we show? So apparently lordship how?
Help it. We are closing it.
Or mediation.
No mediation. This is not a case for mediation, as accepted by you in the last date.
No, my lord.
Show me from materials that 157 that you are claiming is not VGR land. Just show me that. And also now tell me one more thing. Come to para 2.
Or petition. My lord.
Show me from where you were eroded. Where were you before this, before occupying this land? Where were you? You said petitioners being river eroded landless people. From where were you? There will be somewhere, someplace.
Yes.
Huh? If you were river eroded, where are those certificates? Displacement certificates issued by the Gambura or the district authorities.
Perhaps they have submitted it before the authority. Accordingly, allotment was also issued.
You have not even named the village from where you were residing, which was river eroded.
The allotment order, my lord. Here.
Forget it. That is here. Prior to that, where is that basis? where you had lands, your lands were eroded, you came here. What is the description of the land? How much land did you have there? Where are those particulars? We'll not entertain this. Do you want further? Or these 2 points will do? At 2 o'clock, you prepare.
My lord,
2 o'clock.
my lord, tomorrow.
2 o'clock, not tomorrow, today, 2 o'clock. There are life of people involved, somewhere residing for a long time. That's why I'm giving you time till 2 o'clock. Otherwise, my order is ready. I'm clear. Not
There is a
tomorrow.
problem, my lord.
What problem?
Tomorrow, my lord.
Not today, 2 o'clock. Come here at 2. Convince me that I should give you time till tomorrow. 5 years, you have done nothing. Okay. And if there is even a day's adjournment, it will be not less than 25,000.
When, my lord?
2 o'clock.
21.
Wait, please, your lordship. Challenge has been made before this honorable court on the basis of subsection 4. They have issued, they empower learned members.
Which is absolutely illegal. It's absolutely illegal. A division bench consisting of a judicial officer should consider. They have made it to a single bench. Absolutely illegal.
And
Absolutely illegal, right? But is it not a ground for appeal? Is it not a ground for appeal?
the reason of not filing appeal because we are challenging the notification.
Forget the notification. If the
Because
if
the
the
notification
notification
says-
is something issued by the authorities exercising a power under this act, if that exercise of power led to a passing of an illegal order, it's always
Why-
open to
why
you
we
to
have challenged by way of petition, my lord. Because, my lord, in the note.
I'm sorry.
My lord, I will apprise it thereafter. Your-
You do.
My lord, in the order, it is written that learned single member will decide the issue of relating to terminal charge on the basis of, my lord, division bench decision of the learned tribunal.
A railway claims tribunal.
My lord, it amounts to, my lord, directing learned member technical to decide the matter in a particular manner. It cannot be said that you.
That's what I said. This is a ground, bold ground, first ground that you can take.
Will also.
In an appeal, it's open to you. Appeal, see, when we
appeal
exercise
section-
power of appeal,
Appeals.
when I'm exercising my appellate jurisdiction, everything is open to me.
My lord, section 23.
Huh.
23 says, my lord.
23.
Appeal. It says about judicial order. I am challenging the administrative order, my lord.
Sorry.
As provided in subsection 2 and notwithstanding anything contained in the code of so and so or in any other law, an appeal shall lie from every order, not being an interlocutory order of the claims tribunal to the High Court having jurisdiction over the.
Any order.
Whether
Any order.
whether the administrative order come under the purview of any
That
other.
administrative order is something which is there between the bench and the principal bench. Nothing to do with you. If you were aggrieved, you should have come up before the passing of the order.
For passing, how can I come, my lord, after passing?
No,
When the-
no. When that order was there to your knowledge, you should have
It
come.
was filed, it was 2020 and it was filed in 2021. Before that also we approached this honorable court. This honorable court remanded the matter to the tribunal to make a prayer before the tribunal for sending the matter before division bench. It was
See,
rejected.
that aspect was already considered by this court, while its order dated 15/3/2021.
That in the case of my lord.
Where is that administrative? Where is that administrative order?
That is my lord. File down. Oh, there it is. Page 46, my lord. Order dated 16/10/2020. May I read your lordship?
With reference to.
I've got it, I've got it.
My lord.
This power is relatable to 4.
But in the order, your lordship will find, it is written that you decide the matter on the basis of division bench, double bench matter.
Even if that is not written there, let us say that it is not written there. The division bench is a coordinate bench of the tribunal. It's automatically binding.
Binding, my lord.
It's
But
automatically binding.
It can be distinguishable also, my lord.
If that is the issue, do it in an appeal. Show that this.
Number one. Number two, learned tribunal has given power only to decide terminal charge matter. But in learned member has decided.
That is a ground for appeal, Mr. Goel. If it has been decided without jurisdiction, that is a ground for appeal.
Appeal and writ petition, my lord.
We will not entertain a general order like this. This court is of that view. 4-4, the power is determinable.
But Roger Matthew says, my lord, it amounts to dilution of, my lord,
Fine. But the context in which it was said, that also has to be taken note of.
Fine.
It's in a different context altogether, which is not attracted here. This court's view. I've gone through.
My lord, in fact, my lord, CAT, Administrative Tribunal
In
Act,
CAT,
is pari materia to the provision of.
in CAT, the power is there to decide certain cases.
Here also.
Certain cases, if it is found that those cases were not to be decided in the manner required, your only grievance is that the order, 4-4 order, says that follow the division bench order. See, even without that, it is automatically binding on the bench.
Deciding the matter other than terminal charges also.
That is a ground for jurisdiction. It's a jurisdictional error.
My lord, why I have come in by way of writ petition, my lord. Earlier, one of the similar situated person approached this honorable court.
I have dismissed one of the writ petitions also. The matter was withdrawn after considerable deliberation.
In this case, my lord,
same issue.
I have prayed before the learned tribunal kindly refer the matter to division bench as per the Supreme Court decision, my lord.
It was not done.
Supreme Court says, my lord, if request has been made, generally it should be sent to.
Generally. And if it is not sent, there is an order passed, prima facie illegal order. 23-4 is the way out. 23 is the way out.
That I was not thinking in that line, my lord. In that
You will have to think now.
Tomorrow your lordship may take up regarding appeal and writ petition. Otherwise, I will apprise your lordship on merit, my lord. This is a case where your lordship will like to interfere.
I'll not do that. We are not here to stall the proceedings of a tribunal.
Tribunal proceedings are not being stalled, my lord. They are functioning. There is no stay order.
How can I restrain the Gauhati bench of the learned tribunal from adjudicating matters
Because
singly?
Roger Matthew says, my lord.
Okay, show me the provision in Roger Matthew.
Compilation I have given.
Compilation of any.
My lord may kindly directly come to page
260.
408, para 168. It starts from 260 and relevant page 408, para 158. In Madras Bar Association.
Where?
408 page number.
Running page number.
Running page number. Bold. It is typed page. Go 408. At the
Para?
right hand side. And para 158. In so and so, a 5-judge bench of this court reiterated the urgent need to monitor the pressure and or influence of the executive on the members of the tribunal. It was asserted that any tribunal which sought to replace High Court must be no less independent or judicious in its composition. It was also clarified that members of the tribunal replacing any court, including High Court, must possess expertise in law and shall have appropriate legal experience. Even though Parliament can transfer jurisdiction from one traditional courts to any other analogous tribunal.
Show me the portion wherein this court has said that the learned single benches should not hear.
Hence, in any adjudication transferred to a technical or non-judicial member is a clear act of dilution or and encroachment upon the independence of judiciary. It was further.
This is on a different context altogether, Mr. This is on a different context. If you can come to the final
Different tribunal, my lord.
it's not a tribunal.
Dealt with different
Taking up one line from an order and then making a submission that single benches, when the power is already there under court.
So I am challenging the power.
If you are challenging the power here, challenge the provision of the act.
No, notification.
You challenge the notification is perfectly fine because its jurisdiction is from
because the notification
4.
That notification is against the judicial discipline, my lord, directing that.
You do one thing. I'm giving you liberty. Go and challenge 4. That will be the end of the matter. Challenge 4.
Validity of
that this should not be given. It's in violation of Roger Matthew. That will give a closure to everything. Otherwise, this is
another case, my lord, because it may be converted into appeal because
it will not be converted into an appeal.
Because, my lord,
it will not be converted into an appeal. Rejected. Yes, Mr. Goswami, you are paying for?
Tribunal.
What is your submission?
Already notification has been section 4. And secondly, the Supreme Court in 1994, SEC stated that there cannot be any difference between.
They are both same.
The Gujarat High Court, that judgment.
And the judgment of Justice, Honorable Justice Padriwal that you have, Gujarat, that is an appeal.
Okay.
That was an appeal, not a writ petition.
Absolutely.
So,
I am leaving, my lord, whatever your lordship.
I can, if you want to withdraw, I can give you liberty to approach the appellate tribunal subject to provisions of
appellate
court. Appellate forum in terms of 23. Okay, any objection, Mr. Sharma? Heard Mr. A. Goel, learned counsel for the petition. Also heard Mr. Goswami, you are appearing for respondent number 4. This is item number
21.
Heard Mr. S.K. Goswami, heard Mr. B. Sharma, learned. You are standing counsel. Standing counsel railway is appearing for the respondent number 1 and 5. Also heard Mr. S.K. Goswami, learned counsel, appearing for the respondent number 4. Full stop. Mr. Goel, after attempting to argue the matter at some length, has submitted that he be permitted to withdraw the present writ petition with a liberty to approach the appellate forum in terms of the provisions of section 23
of the Railway Claims Tribunal Act.
Section 23 of the Railway Claims Tribunal Act 1987 against the order of the tribunal passed in the original application involved in the present proceedings. Also, prayer accepted. Also, prayer is not objected to by the learned counsel for the respondents. Also, prayer accepted. The present writ petition stands dismissed with a liberty to the petitioner to approach the appellate forum in terms of the provisions of section 23 of the Railway Claims Tribunal Act 1987. Full stop. With the above observation and directions, as per to likhi liberty with liberty and
only my condonation part, my lord.
Full stop. What is the law?
How is settled?
In the event the delay is the liberty is given to the petitioner to take the petitioner is at liberty to file appropriate application for condonation of delay and therein also take a plea with regard to the pendency of the proceedings before this court, pendency of the present writ application before this court. So the appellate court, if so permissible under law, would be permissible of under law, would be in a position to entertain the said interlocutory application if so filed. Deeply argued.
Filing affidavit.
Mr. B.J. Talukda, Learned Counsel, Learned Senior Counsel, appearing for the state respondents, assisted by Mr. P.K. Medi, Learned Counsel, submits. Mr. P.K. Medi, Learned Counsel, assisting Mr. B.J. Talukda, Learned Senior Counsel, appearing for the state respondents, submits that an affidavit on behalf of the respondents represented by them shall be filed during the course of the day. First, registry to list this matter again on 8/9/2025, along with the affidavit that is undertaken to be filed during the course of the day by the respondents. Petitioner would be at liberty to file his rejoinder thereto before the next date of listing.
In 22, my lord, my respondent number 8 and 9 have filed their opposition, my lord, 14th.
Okay, we'll give a 1 week time. Mr. B. Deca, Learned Counsel for the respondents number 8 and 9 has submitted that an affidavit on behalf of the respondents represented by him has been filed on 14/8/2025. Full stop. The Learned Counsel for the petitioner submits that she be granted a week's time, 2 weeks time to file a rejoinder thereto on behalf of the petitioners. Prayer accepted. Registry to list this matter immediately after conclusion of 2 weeks from today.
Okay.
Yes, Mr. Sharma. Yeah, I wrote on next file today. Yes.
What are it?
Okay, argue. First and foremost, argue the power under which you invoke for issuance of that. No, you're given enough time. No more accommodation. It's either Meghalaya or Nagaland. Show me any writ petition wherein Assam coal is involved. 2267. 2267 there. Hmm, 2267. Can't help it. That was your headache to manage. It's not my headache. You never made that mention in the earlier roundability dates. In the earlier dates, you have not made a mention of that. I can't help it now. 29. Okay.
Has taken a permit.
Hmm.
Then here,
That is for his registration as a supplier. Hmm. But show me that the coal that is involved is Assam coal.
not the issue there.
In any of these matters, is Assam coal involved?
Take it, Lordship. If the documents and the code, if they show me the documents, ask the documents, then only we will know. That it
No,
is
show me the power. Show me the power under which you are making that statement. Either in the Constitution or in the Minerals, Minor Minerals Act or anywhere. Show me that power. Constitution of India.
uh,
So, I'm sorry, we have been accommodating you for the last around 3 days.
yeah, Lordship, if you, Lordship, all the parties are also not there. Petitioner, all the petitioner is also not present, Lordship.
I don't want it. I'm hearing it. That writ petition is placed before me. I'm required to answer.
Order which was modified, Lordship. That way, Lordship can.
I'll not pass an order. I want your jurisdiction. Or I'll record that you have made a submission that the jurisdiction is not traceable. The order was passed without jurisdiction. End of the matter. You say you can't show me the jurisdiction from where you are drawing this power. Show me that. You have issued a communication. Show me the power which is there to issue that communication. Simple. If that is traceable to some source, we will examine. If not, gone.
Take up this matter at 3, Lord.
I can't. I will take it up now only. Mr. Sharma, you make legal arguments. Forget factual matters. You have issued a communication dated 10/2/2022. Show me the power. Who asked you? Who prevented you? Did I prevent you? Did any one of the petitioners prevent you? Just tell me, I will take action against them now only.
My fault, Lordship. I could not take up.
Then you have to suffer.
Then
Because I have been adjourning this matter on your prayer from last March. I mean the coordinate benches also.
Coordinate bench,
March, April, May, June, July, August end.
the change of officer, Lordship. So I was not sure whether I will appear or not.
So you were sure on the last date?
On the last day.
And what is the order?
I have to.
What is the order on the last date? Specific order. Show me the power.
That the Lordship has
And what is the what
whatever
is this
argument
document you have thrown to me? Make your argument on law. Make it.
Lordship,
I'm hearing you.
they have
Take
given
the
me
whole day,
not
no
only
problem.
This order only 16.8, Lord.
That is it on law.
That is all, Lord. That I have to prepare.
An advocate is always prepared on law. Sorry. I'll adjourn it. Each case, 5,000. Each case, 5,000. Give me. Deposit with the registry. I'm adjourning this. I have been wasting time. You are wasting judicial time.
Lordship, I have given
If you don't make a submission on jurisdiction, I'm going to record that you have made a submission that this order was issued without jurisdiction. You said little bit, I can't trace the power. You said I can't trace the power. That means what? No jurisdiction.
I am going only to that annexer, that communication point that by
Go through that.
order that they have issued the order requirement of NOC. Say that it was not, it was issued without.
Then where is the power?
In this order,
or was not stated.
So you will have to tell me from where, it need not be stated there. You can derive that power, you can make your submission, see.
Because they have not stated.
Okay, study till 2 o'clock, come back at 2 o'clock.
Okay.
Or if there is an adjournment, it will be with cost. We will not allow this casual approach. Mr. Goel, 2 o'clock. Mr. Sharma, anything more left to be done?
My lord, they have agreed. Yes.
We'll just close this with this observation.
That they have agreed to settle.
What's up? Heard Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr. D. Dole, Learned Counsel for the petition. Also heard Mr. Mr. B.J. Talukda, Learned Senior Counsel, assisted by Mr. P.K. Medi, Learned Counsel, appearing for the respondent's number 529. Also heard Mr. A. Bhattsaji, itu upor likhi diba. A. Bhattsaji, Learned Counsel for the respondent's number 1 to 4. 1, 1, 3, and 5.
4.
1, 3, 4. 1, 3, 4. Also, the petitioner, by way of instituting the present proceeding, has prayed for a direction upon the respondent authorities to settle the land, to settle the land allotted to him. Settle the land measuring 1 kata 3 lessa, covered by DAG number 175 old. Settled to him in terms of the communication dated. Where is that 31/2008? Mr. Sharma? That 3 lakhs thing
Yes, they are able to.
in the writ petition?
Yes.
In terms of the communication dated 31/2008, bracketed Annexure B to the writ petition. Also, a perusal of the communication dated 31/2008 would go to reveal that the land in question was directed to be settled by with the petitioner herein at a land value which was fixed at rupees 3 lakhs only per kata, and the possession was directed thereafter to be handed over to him and the land records corrected accordingly. Also, it is seen that the petitioner had not paid the premium of the land in question. Premium as determined the land in question initially. However, thereafter, the petitioner had issued communications to the respondent authorities expressing his desire to pay the premium amount as determined via the communication dated 31/2008. However, the respondents had taken a plea that the said land would not be permissible to be settled with the petitioners herein in view of the fact that the land in question was reserved as apostrophe diba go reserve GO-reserve. Full stop. On the last, this court had directed Mr. B.J. Talukda, Learned Senior Counsel, to receive his instructions in the matter. Full stop. Subpara. Today, Mr. B.J. Talukdar has placed on record instruction dated 18/8/2025 issued to him by the District Commissioner, Kamrup Metropolitan District. Also, the contentions raised in the said instructions dated 18/8/2025 being relevant is extracted here in below. A to A. A perusal of the contentions raised in the said communication would go to reveal that the de-reservation of the Go Reserve, GAU reserve, has already taken place in favor of 41 families, including the petitioner herein, and accordingly, the District Commissioner has undertaken that the settlement process of the proposed land would be proceeded as per rules and procedure after realization of the premium as assessed by the government via the communication dated 30/1/2008. Also, in view of the undertaking now placed on record from the District Commissioner, Kamrup Metropolitan District, this court is of the considered view that the present writ petition would not be required to be detained any further and can be disposed of by directing the District Commissioner, Kamrup Metropolitan District, that is the respondent number 5, to take forward the issue in accordance with law and to settle the land in question with the petitioner after realizing the premium amount in terms of the prescription made in this connection via the communication dated 30/1/2008. Also, the above exercise be initiated and completed within a period of 3 months from the date of receipt of a certified copy of this order. With the above observations and directions, the present writ petition stands disposed of. A copy of the instructions dated 18/8/2025 furnished by Mr. B.J. Talukdar, Learned Senior Counsel, is kept on record and marked as X for identification. Any objection? Miss B. Idas, a learned counsel appearing for the respondent number 2 and 3, submits that the matter be adjourned today on the ground that the arguing counsel, Mr. S. Dr., senior advocate, is not present, is out of station. Also, prayer is not objected to by the learned counsel for the petitioners. Accordingly, a registry to list this matter again on 10/9/2025. Mr. Chutia, has the money been released? Okay. Mr. Chutia submits that the process for release of the arrear salaries of the petitioner with effect from 25/1/2021 to 9/3/2023 is at an advanced stage of processing and the necessary and would be released on or before 28/2025. Registry to list this matter again on 21/8/2024. Right? But this time do it. 21.
Fixing on 21st.
21. It will buy slip code.
May I please, as per last occasion,
have you got it?
This is the communication, Malab. What happened on the date? I approached the authority, but
Yes, Mr. Chetri.
Lordship may see this one. On 6/8.
That communication is already incorporated, dear Malat. Also to that communication, as well as this Dishonorable High Court's direction, I approach GPR's Malat position is dear Malat.
Here maybe.
I approach the authority. And what happened? They refused, Malat. And in fact, Malat, some miscreant political nexus is there. Some persons are also threatened me.
Why was the amount not? Why should we disbelieve a senior citizen?
Because it is
Why have you not?
No, because this is his allegation that he is some misbehavior.
Okay, why this amount was not received by you?
Because then Lordship may come to page 2 in my this is the receipt of the RTI document. So because the acknowledgement from this one acknowledgement from him. If coming some other day say no, the document is not proper and not submit to me, does it would have any evidence to prove this that all the document what have he want? He is not received.
How many pages are there?
Then let's see, we come to page 1.
Okay.
301 page.
Have you paid the money?
I approached to deposit.
Have you paid the money?
No, they refused to.
They refused to take. Okay.
The official staff of that organization has refused.
Mr. Chetri,
Then Lordship may
carry this material. No. We don't want to be the place where you will give information. There is a dispute raised. Who's up? Mr. Goswami, UK Goswami, learned counsel for the petitioner, submits that in terms of the directions passed by this court on 23/7/2025, he had approached the Public Information Officer, Jorat Development Authority, for being furnished with the copies of the documents sought for by him under the provisions of the Right to Information Act 2005. However, he submits that although he had expressed his readiness to pay the amount so determined as cost for handing over the copies of the documents, the office staff of the Jorhat Development Authority, the staff of the Jorhat Development Authority refused to take the amount and had also behaved rudely with him in the matter. Also, the fact that the petitioner had approached the Jorhat Development Authority for being furnished with the copies of the documents so sought for by him is not disputed by Mr. Chetri, learned counsel appearing for the Jorhat Development Authority. However, he submits that the petitioner, on being furnished with the documents, had refused to take copies of the same. First up, in view of the dispute so arising in the matter, the chairman, Jorhat Development Authority, is directed to approach the Deputy Commissioner, Jorhat, with the documents so sought for by the petitioner, copies of the documents so sought for by the petitioner, and in presence of the Deputy Commissioner and or an officer authorized by him, to hand over the same to the petitioner after receiving the required cost for the same, which is now quantified at rupees 5,254 bracket 5 rupees 5,254 bracket of
the money received.
So and so. Also, the Deputy Commissioner, Jorhat, is a District Commissioner, what a Deputy Commissioner, is requested to facilitate the handing over and taking over of the documents by the petitioner and the Jorhat Development Authority, either in his own presence and or in presence of an officer deputed by him for the purpose. The petitioner shall furnish a copy of this order before the Deputy Commissioner Jorhat, who shall thereafter fix a date for the handing over of the documents to the petitioner by the Jorhat Development Authority, either in his presence and or in presence of a officer deputed by him in the matter. For so, the petitioner to furnish a copy also registry to list this matter again on 3/9/2025, full stop, on which date the respondents for the parties shall apprise the development taking place in the matter. Now go before the Deputy Commissioner. Hand
You
over.
may receive the.
This gives rise to a very bad vibe that there is something. What is the need of a 70-year-old man?
No, because there is a.
A
case between the-
70-year-old man, and he is making allegations. We are not going into that. But on the next date, if it does not happen before the district commissioner, then what is to be done, we will do.
Because there is a clause between the.
Whatever documents he has sought for, 1 to 100, 1 to 200, whatever it is, serialize it, give it to him.
Well, already done because he is not.
And Mr. Goswami, they can give you the documents they have. If there is something left out, you can always ask for that.
Definitely.
But you can't refuse.
Yes, that is
That is a false
that-
allegation.
No, detail-
I haven't threatened to come out from the office. That is the problem.
It will be so on 6th, 8th.
And where is the
we
police
visit all
report
the
to that
petitioners.
effect that you were threatened?
I submitted
Where is that police report, FIR filed by you?
a copy of this letter is marked to the officer in search. Malat, you'll also look into it.
That will not do. You file a FIR. If that next time it happens, file an FIR. Then we also know the bona fide.
Malat.
So now go before the Deputy Commissioner and get your documents. Clear this matter up.
Already.
Or I'll have your chairman here with the documents. And the cost and the petition also here, cost paid by the chairman. Next day. He'll come in a AC car from there to here. Cost will be paid by you.
May I please, Your Lord? My lord, here initially there were.
Mr. Roy, for my benefit that you are here now, as an officer of the court, the issue here is release of the areas of rent and the rent, current rent. That's the case.
Rent has been deposited in the bank
Fine.
account.
Respond number 3's account, the matter has been deposited. But the petition number 3's account. Now the respond number 3 on the same very issue has instituted a civil suit. And that is pending.
Pending.
Why don't you make this prayer there, not here? Because that issue is before the civil court, along with your own.
See, before the civil court, she has filed an ejectment suit for the ejectment of the bank.
And she has also filed a suit, subsequent suit, that is 650 of 2024, on the same very issue that is there in the present writ petition.
So, Lordship, here facts are a bit different, Lordship. The bank is.
Just clarify this aspect of the
Yes,
matter,
yes,
Mr. Roy.
Lordship. Because, Lordship, first of all, the respondent number 3, in spite of service of the notice, has not appeared. No affidavit in opposition has been filed. So the matter is proceeding ex parte, Lordship. Which shows
But
that.
what about the suit filed by her? Title suit number 650 of 2024.
Lordship, in that suit, she is claiming that she is the second wife of late Suman Talukdar, Lordship, which we had denied, Lordship. And she forcibly occupied the ground floor and the part of the second floor.
Those are issues which is now pending disposal before the learned tribunal.
Lordship, may be pleased to consider the fact that the petitioner number 1, her name was Nirupma.
She has been deleted.
Nirupma Talukdar. She was aged about 88 years. And Lordship, we could not provide the medicine a proper treatment, and she expired in April 25, Lordship.
She is the, how is she related to Suman?
Suman was the son
Son,
Srimati
first son,
Nirupama Talukdar, Lordship.
46 years.
And Lordship, the actual wife, who is the respondent, Lordship Barnali Das, petitioner number 2, Lordship. She is a widow because Suman Talukdar husband expired in 2019, Lordship.
And this
his son,
respondent number 3 has projected herself to be the wife, along with certain documents wherein the house property, okay, it's a notarized document, which was handed over to her as in the capacity of wife. You have filed a title suit. She has filed a title suit. If you can come to page 180.
He has filed a
Page 180.
180.
The prayer number B.
Yes, a degree.
So when this is there, why should I exercise when that matter is disputed? It's before the competent civil court. Why should we come in?
Lordship, assuming not admitting that the respondent number 3, Mamoni Devi, she is the second wife, Lordship. In that event, Lordship, when the petitioner number 1, 2, and 3, Lordship, petitioner number 1 has already expired in April
2 and
25.
3.
So, assuming that she is also the wife, then what will be the share?
That is why
bank may keep.
That is why the bank cannot do it, Mr. Roy. I'm sorry, the bank cannot do it. You are before the civil court. Go and get a declaration or a decree or a order from the civil court. Do it. Because the matter is already.
The suit filed by the petitioner.
Maybe get it dismissed. Get it dismissed. You have already filed your written statement in the matter.
The respondent number 3 filed in the suit filed a counterclaim for declaration of her marital status, which civil court cannot grant because
Fine. That will be by the family court.
Lordship may.
But what about this prayer in B? I can't say that this prayer is bad. This prayer is not maintainable.
Lordship, already I have submitted but that 1/3 of the rent, the bank may retain, Lordship.
We will not.
And the rest
we will not. You get that order
Lordship,
from the civil court.
None of the petitioner before Lordship having any income, Lordship.
Get that order the earliest.
Starving, Lordship.
Get the order from at the earliest from the civil court. These are disputed questions.
The bank is not a party. That prayer I cannot make.
No, you can make. She has already made a prayer for a decree for realization of the arrear rents and also the current rents.
Current rent, Lordship, but my humble submission is this bank is not a party. In the earlier suit which was filed by us for the declaration of right title and interest, Lordship.
But in this present suit, the bank is a party. That suit filed by
bank recognizes the petitioner as the landlord.
I know, only by the virtue of that deposit in the account. There is a status quo order already passed.
A status quo order is in
respect
to
of that
maintain the
property.
status quo regarding the possession.
And now, what is
no injunction.
Is there any order, interim or interlocutory order passed in 6/50/2024?
No.
Who is appearing for the respondent number 3 here?
No, none. No affidavit, none.
I'm sorry, my considered view is that this court should not enter into
Lordship, what is the definition of the landlord and tenant, Lordship? The person who is receiving the rent, he is the landlord.
If that was the general position, Mr. Roy, we would have accepted it. But now with this developments taking place in the matter, this court will refrain from doing that.
No, there is no injunction against the petitioner, Lordship, or against the bank. Bank is not a party, Lordship. How the petitioner will survive, Lordship?
Yes, Mr. Sen, what do you say?
They have no income.
Okay, I am correct. That's a different thing. But what are you? What is your stand?
And Lordship, the bank, Lordship, hold up the account, Lordship, before filing of the civil ejectment suit by the respondent number 3. Lordship, will be pleased to peruse the plaint. It is a suit of Lordship. May come to suit of 2024, where our suit has been filed in 2019. Since 19, Lordship, the petitioner number 1, Lordship, he is a she was the grandmother expired. Petitioner number 2 is the actual wife, lordship. She is widow, no income. Petitioner number 3 is the son of Suman Talukdar, lordship. He is unemployed, though he is engineering graduate, but no employment till date. How the people survive?
Mr. Roy accepted everything, but we'll also have to have, there is a proceeding pending before the civil court wherein the issue is to be decided. Whether if she is the wife as claimed by her, it
No,
would be a
Lord,
different connotation.
bank is paying, depositing the rent every month in the account.
Pleadings are complete here. Any further pleadings to be brought on record?
No.
We'll hear it then.
It will be next lordship next week because
Heard Mr. S.P. Roy, learned counsel for the petitioner. Also heard Mr. B.K. Sen, learned counsel appearing for the respond number 1 and 2. Full stop. In spite of service of notice, none has entered appearance on behalf of the respondent number 3. Also, it is stated at the bar that the pleadings in the matter is complete. Also, accordingly, registry to list this matter again. It's stated in the bar that the pleadings are complete and the matter can be taken up for final disposal. Also, registry to list this matter again on 15/9/2024 for admission hearing. An endeavor would be made to dispose of the matter on the next date of listing.
Deeply obliged, my lord.
With the lordship, my lord, in this matter, we have although it has
Give me a copy. Where is Mr. Nayak?
my lord, we have, in this petition we have challenged the maintainability also because my lord, the petitioner himself have violated the norms and down by the DMC and
That you make a complaint, let that be
he has
taken.
made the complaint, but
Okay, fine.
when he himself has violated, my lord, he cannot claim, my lord.
But
He
here
should
there is a
come
clear
to
cut,
my lord.
there is a clear cut finding of the authorities that neither you have constructed the building in terms of the plan. Forget the setback. You could have got only a G+2 or a G+1. You have made that report is different.
Yes, my lord.
The report is different.
Because in our affidavit, we have said so that.
Do you want to file a rejoinder to the affidavit? You want to file? Mr. D. Bora, learned counsel for the, for DP Bora, learned counsel for the respondent number 4, submits that an affidavit on behalf of the respondent represented by him has been filed today. Also, Mr.
B. Kalita.
B. Kolita, learned counsel for the petitioner, submits that he be granted 2 weeks' time to file a rejoinder thereto. Prayer accepted. Registry to list this matter again after 2 weeks on a date to be fixed by it. But this is a matter, where is Mr. Naik? This is a matter, things have come on record and there is an affidavit also by the, I think, GMDA authorities. Very categorical. And the latest order of the Supreme Court direction says when there is a violation, and these are violations which, that we will also demolish. We'll ask them to demolish that also. But first, we will consider your demolition. First, we will consider your demolition.
Affidavit also, my lord.
We'll consider everything. But the issue is, Supreme Court has said, this cannot be compounded. This violation is not compoundable.
And his construction, my lord. No
Okay, fine. We will ask the GMD authorities to examine that also.
Yes, my lord.
But yours, you are accepting that it's liable to be demolished.
We have constructed only G+2, my lord.
That is for the report given by the GMD. 2 weeks, after 2 weeks.
Obliged.
It took great idea. Yes. Miss Kempra, no. Oh, wrong hand. No.
Join in default.
Required to deposit 10 rupees. That individual amount so that he can find arbitrator matter.
The entire compensation that was determined has been released. So if there is any enhancement, he'll have to approach the Kala for reference to the arbitrator. For reference through Kala only.
Can go to the directly getting the my lord. Section 3.
Who is for the petitioner? Can you just ask somebody to just find out whether he is there? Then we'll finish up. We'll dispose of the matter today itself. Yes. Why there is no representation today? None has appeared for the petitioner on call. Ms. M. Borman, learned government advocate, appears for the Mr. A. Bhachaji, learned standing counsel, revenue and department, appears for the respondent number 1, 2. Whereas Ms. M. Borman, learned government advocate, appears for the respondent number 3. For the ends of justice, registry is directed to list this matter again on 5/9/2025.
May I please?
On the last occasion, my lordship got some instruction from the deputy commissioner. Appears that they are supposed to give instruction as to the implementation of the my lord action plan. This action plan, in my submission, that is my challenge. What happened in this case, my lord?
Let me first see what they have. Yes.
My submission is that, my lord, lordship kindly come to page 35 of my writ petition.
30?
Before that, there are some court's order, my lord, in which, my lord, courts instructed the department to, there was excess money, which was what.
Those things have gone.
These are over, my lord. After that, my lord, page 35, second paragraph. Further, I am to inform you that the annual action plan for the year 2020-21 to 2024 already submitted to your good office for according DPC approval. These are the approval. These are the, my lord, action plans submitted by the elected Gau Panchayats, my lord. And by holding Gausaba. Thereafter, what happened? Page 37A, Annexure 8. They accorded approval for the first installment of 2021-22. Plan was submitted up to 2023-24. From March onward, there was no, my lord, Gau Panchayat because of the expiry of the term. Then what happened, my lord? Ignoring the, my lord, earlier action plan submitted by the earlier elected Gau Panchayats, the MLA of the concerned constituency has submitted some proposal on 4/6. I have filed an additional affidavit that is there, my lord.
I have it.
That is there. On which, my lord, this was submitted on 5/6, page 58, running page. These are the proposal for the year, my lord, from on 5/6/2024, he has submitted some schemes, ignoring the earlier action plan submitted by the Gau Panchayat after holding the under section 126 of the Assam Panchayat Act. DPC has accepted these proposals and they have come forward to execute this scheme. Ignoring this action plan submitted by the elected GP and the by holding Gausaba. Page 60. The action plan in page 58 were ditto followed by the DPC. And these are the action plan president signature. My lord, this is not the president. This is the block development officer who is the in charge of the Gau Panchayat for the stopgap arrangement, my lord, for that relevant point of time. He has submitted and they follow this scheme only. So my submission is that they should follow the earlier action plan, my lord.
They have already implemented.
I have filed a petition before that, my lord.
Fine, but they have already implemented. The people are benefited. So why should we enter? If there is anything, if there is an allegation of misappropriation of something here, which you allege, go and file a criminal case.
What I'll do, my lord.
Go and file a criminal case.
Let them, my lord, serve a copy upon me so that I can.
You can have a look.
Lordship will take up the matter.
This is by the district commissioner. He says that this is the manner in which it was done. Fine.
Yes.
The amount has been done, the work, and if there is anything amiss here,
yes,
you go institute criminal cases against those people.
So Lordship may take up matter on a Friday, my lord.
Today.
I have to sort instruction, my lord.
Have your telephonic instruction? We'll have it at 2.
On Friday, my lord, or Thursday, my lord, whatever, my lord, Lordship can do.
Tuesday. Mr.
Tomorrow, my lord.
Tuesday, next Tuesday. Mr. Who has produced this instruction? Mr. The Learned Government Advocate has placed on record the instructions received by him from the District Commissioner Sri Bhumi in pursuance to the order dated, in pursuance to the directions passed by this court, wide order dated 28/7/2025. Also, the Learned Government Advocate shall furnish a copy of the same to Mr. J.M.H. Chaudhary, Learned Counsel for the petitioner for his perusal. Also, matter be listed again on 26/8/2025 for on which date the Learned Counsel for the petitioner shall make his submission basing on the instructions furnished in the matter by the District Commissioner Sri Bhumi.
This case may be tagged with, my lord, WPC 4736/2024.
Why?
I have filed one affidavit, my lord, that will cover this case also, my lord.
What is your stand there?
Then, my lord, that porcupine, my lord, is not under permissible work under MGA and Rega, my lord.
Now, why did you give him an order for that effect?
For that, my lord, they have to.
No. Why did you give him an order? He did it only in terms of your supply order.
My lord, those were by the districts only, my lord.
Whoever it is, he has not done it on his own. What action have you taken against those district people who have made that order?
On emergency.
So why should this man suffer?
Some other.
Okay, I got it, but he has not done it on his own. Public interest. He has done it on being directed. So he should be released. If not, the authorities who have given the order, who was the authority who gave the order? The authority who gave him the supply order,
The
who,
district commissioner, my lord.
under district. Have you proceeded against the district commissioner?
But that was under emergency, my lord, because flood situation.
So if that be so, how can you take that plea?
There-
It would be a different question that he has not affected the
Lord,
supplies.
may I submit, my lord? Central government project, my lord. If they will not allow us, my lord, under the project, we cannot, my lord.
We can't help it because if that is, this man is concerned, he did it on being directed by somebody. He expended money. If he has given the supplies, he has to receive.
My lord, and in that case, my lord, we have filed that affidavit, my lord. Lordship may pass an order. There are some 4 or 5 cases, my lord, similar, my lord.
Along with,
Along with, my lord, 4736, 2024.
Mr. S. Dr. Leonard, Standing Counsel, Panchayat and Rural Development Department submits that an affidavit on behalf of the respondents represented by him has already been filed in WPC numbers 4736/2024, and the same would also cover the issues arising in the present proceedings. Accordingly, registry is directed to list the present writ petition along with WPC number 4736/2024 and list the same after 2 weeks from today. Also,
There are other 3 cases also, that also may be.
that will be tagged along with that. It's already tagged with
No,
that.
not tagged.
Registry accordingly to list this matter along with WPC number 4736/2024,
And 5431, 2024,
5431/2024,
5406, 2024, and 5434, 2024. Still 5 cases, my lord.
Pasta bolne, ituk logi ne pasta. Pasta. After 2 weeks on a date to be fixed by it. A copy of the affidavit so filed in WPC number 4736/2024 be handed over to the counsel for the petitioner in the present proceeding.
May I put a date, my lord?
Hello, please.
I'm the. Wait, please.
Yes,
The
Mr.
reply was filed in this case, my lord.
We have got it. We have got it.
What happened, my lord? Another
Mr. Sharma.
Another
Mr. Sharma.
Another writ petition that is also pending.
That is for the other part.
My lord.
That we have
Well,
got
it has
nothing
a
to
bearing
do.
with the, my lord, present.
Maybe that is for the further assessment of compensation.
My lord.
But here it is whether that 12 plus 4 lakhs is a money paid to you
My lord.
or paid to you on behalf of all the patanas.
Can we see the 3G list, my lord?
No. Your contention is that this money was only paid for the land acquired by from you. Nothing else. Is that your final stand?
My lord.
Okay. Come to the affidavit.
Before that, your lordship kindly peruse, my lord, the 3G.
Okay, 3G list, we'll go to that. We'll go to that. We have seen the 3G list. And there is agreements also
My lord.
between the co-patanas. Now you come to your page 87 or your page 63, para 8 of your reply.
My lord. Well, one problem, my lord, the copy, my lord, that has been, my lord, not.
Hey, second copy to Asajit Didia. Second copy, teacher. You have a copy of the affidavit in reply file.
Just now I have.
You give him a copy. Just give it to him.
Yes.
Para 8.
The so far statement made in paragraph 6, my lord. Deputy in opposition, the admitted computer issued the check number so and so drawn on so and so, my lord.
But immediately thereafter,
Stated that said amount was disbursed to be shared by the deponent and another which is blatantly false and baseless.
so this 12 lakhs comes to you only,
My lord.
right?
As per the 3G list.
Page list. Now you come to page 25 of your petition.
The agreement. 25 is
So
the,
this and that don't match. And both documents were brought to you by you. Page 25 is also an annexure in your writ petition. And page 63 or page 85, whatever it is a statement made by you. And both are contradictory.
my lord, respondent has clubbed the amount. Your lordship kindly peruse the, my lord, 3G list.
Mr. Counsel, your this document, Annexure 5, is brought on record by you.
My lord, that's true.
That's true.
Kindly page 16, my lord.
16. Okay.
Last column, my lord. Tag number 404. Kindly see the amount, my lord. 12,60,000, 12,60,367 and 50 paise. Now your lordship kindly peruse the check, my lord. Page 24.
Page?
Page 24.
Here this amount is not only for yourself.
It is my amount, my lord.
Arre, here it is, see, come to page 16, Guneshwar Deka
My lord.
and Dhanodhar Deka.
Dandodhar.
Huh?
Dandodhar.
Dandodhar Deka. And Dandodhar Deka is your nephew.
My lord.
When you reach 16 with 25,
Next, lordship kindly page 16, my lord. How
16, huh?
Dandodhar's amount, my lord.
Enlon is both for both. For both.
Dandodhar's amount kindly peruse, my lord, page 17.
17.
Serial number 5.
Huh.
Amount is,
That is 287, Mr. Soikia.
my lord.
This is 404.
404.
So you have not received your amount till now.
No, my lord.
Okay. Under 64, we'll ask the director, deputy commissioner, to refer the matter to the principal
My lord.
court. Let it be decided there. What do you say? Anything else?
My account has been freezed by the authority, my lord.
Naturally, because the check is there. You may misuse it. They will have to make a payment again. So for that, they have done it.
As
And
part
your
of the treat-
statements,
as part of
Mr.
the treat-
Soikia, your statements itself is contradictory to page 25, to page 16.
Sir.
In the reply, you have said, you have made a misrepresentation here, page 87, para 8. Whereas 16, 25 clearly shows that you have also agreed that this money is to be given to somebody else.
This 12 lakhs, my lord, 60,367 is only exclusively for the petitioners, my lord.
Where it's for both. It's for both. There are two names there. And there is an agreement to that effect,
And
Mr.
they have
Speaker.
grabbed the.
There is an agreement. Come to page 18.
That I have.
Ah. Why make this contradictory statements? Why should you make this contradictory statement in para 8 of your reply? Whereas in the writ petition, you are saying something else. Page 25 is again clear that this amount, two amounts, 16 lakhs total.
Total 16.
So mine is 11, his is 5. And why have you not made him a party here?
The agreement is there. It is.
But you are denying.
Before
You are
the circle
denying.
officer, my
You are
lord.
denying. You are denying. You are denying this.
For
Page, Mr. Soikia, it's a very serious issue. Page 25 is denied by you in para 8 of your reply.
My lord, the check, my lord, page 24.
Forget the check. Check is as a trustee given to you. They have got no headache here.
I referred my to the.
I'll not refer. I am dismissing this. I am asking, if you want, you can go. We'll not give you a liberty to a petitioner in this, with this conduct.
General lordship may dismiss, my lord.
Okay. Yes, Mr. Soma. He is at liberty to approach the, what do you call that?
As because
Principal Civil Court. At 2 o'clock, we'll pass the order. And there will be a Supreme Court judgment also, don't worry.
They
I'll
are
rely.
having everything, my lord. They
Huh?
have, my lord, mismatch, my lord, everything, my lord.
Mr. Soikia, if you had stuck to 25, page 25 agreement, that would have resolved the issue. But now, again, in the reply, you have disputed that. So when there is a dispute, this court will not come in. You may get more. You may
Check
get
is
more.
exclusively issued in favor of the petitioner.
That is the mistake they made.
Verifying the amount.
That is the mistake they made.
My lord.
The mistake they
When
made.
they
We'll
have
clarify.
committed a mistake.
We'll clarify at 2 o'clock.
Oblige.
Be here at 2.
The dispute as regard the apportionment, my lord, collector should refer it to the authority. So, my lord, I may be.
In National Highway Act, my submission made by my learned friend is accepted.
But this is under the fair.
Right to fair compensation committee.
We can approach directly.
My lord, your lordship
You
may
go-
look into dispute.
And another thing,
76.
Mr. Chaudhary. The father.
My lord. Both the fathers were the brothers,
Hmm.
and now, my lord, one of the brothers is alive,
Hmm.
and another has expired. Your lordship may turn to page.
So you approach the competent authority.
Page.
Why should we refer? This is a dispute with regard to
apportionment.
apportionment only. Section 64.
Well, 76 dispute as regard under 13 acts.
13 Act to some.
13 act. When the amount of compensation has been settled, if any dispute arises.
And the settlement here, settlement between the parties, family settlement, is by the petition number 1, drafted by the petition number
Well,
1.
no settlement, it is only on the position. We are all the co-partners, only on the basis
You
of.
come to page 35.
My lord, page 35.
This is their case is that only 2 lots of land,
25.
2 lots of land from you were taken, petitioner, one of the petitioner.
My lord,
The
item number
entire land
16.
of 1 katha is taken from the respondent.
No, my lord, WPC is 607 to 24. WPC 60.
7 to 2024.
24. Well, page 35 is not there.
607. Soleiman Ali. What is this then? Affidavit.
We have not been served with an affidavit also again.
Not been served. AK Azad. 21-5.
This one number 5.
It was served on you on 21-5.
What I have got just now, what I have got.
Oh.
Just now I have got it.
What is it? Land 13 Act 2. And right to fair compensation.
My lord, this is the 13 act.
Right to fair compensation.
76. Section. যে মুপরা লই যায় অবজেকশন করল কিতাবটা লই যায়
So 76 apportionment, it will go before the
civil court. This one
authority.
Authority is the civil court, and the state act. Assam. This is a judgment for
wherever it is. That, but you will have to approach the the collector.
Collector. We have filed a representation. If the dispute is there, then he will refer it to the authority. This judgment was there. Your lordship will find in one judgment where it has been stated that the state government has declared the civil district judge. Section 50.
Same like the National Highways Act.
My lord. Section 52 and 53 decides about the appropriate authority. Authority is section 52 and 53 is the qualification. Composition authority is 52 and 53 is the qualification.
There is a judgment of the Supreme Court. Can we have it at 2 seconds? No, I'm not rising. You can tell me.
Sorry to trouble your lordship. One matter is my learned is there. Item number 85, my lord. 85, sorry, I could have mentioned in the morning, but I some personal difficulties. 85, my lord, I am here the contemptor, one of the contemptor.
But you had come on your own. We have not invited you.
Now, but by virtue of that order, with great respect, my lord, your lordship has passed an order saying then again the French
Mr. Das,
demarcation.
this court has not passed any direction.
No, your lordship, I'm telling your lordship. To my understanding, and I have annexed, your lordship has said fresh demarcation will take place. That's what I have understood the
What
order.
has happened is that Mr. Chaudhary had disputed that demarcation exercise to be an exercise done in the air. He had demonstrated. When the matter reached that stage, Mr. Sharma undertook that, okay, we will go for a redemarcation. Now, let us say that order is done. Demarcation is done. There is already a protection from the writ court that the possession should not be disturbed.
No, I'm saying your lordship is absolutely correct. No, whether, my lord, with great respect to your lordship, my lord, whether another order can be passed.
No order has been passed.
No, your
No,
lordship has,
85%.
fresh demarcation.
Mr. Das, if my orders are not complied with in the manner it is required, are my hands tied?
No, I am not saying that. With great respect, I am not saying that, man. Your lordship is always open. I am not saying that lordship hand is not tied. My lord, what I am saying, that a fresh order, file the court.
Poised thus, Mr. Sharma order submits that he be granted 3 weeks' time to undertake fresh process in the matter strictly in accordance with the directions passed by the court, while order dated so and so. There is no order by this court here. There is no order passed by this court.
No, this court, last order passed by your lordships is last order passed by this court. A fresh demarcation will take place.
No, that is his undertaking to save himself from contempt.
No, that is why I am saying.
Then I said, okay, list again by which compliance report shall be filed. I want my order to be complied with.
Very nice, my lord, very well. If that is only your compliance report to be furnished before the court, there is absolutely no
You go through the order. You have made a. We will consider this. We'll consider this, Mr. Das. But the way the matter is being projected,
no, I am not.
It's my discretion.
No, my lord, your lord.
You go up on appeal.
No, I will not go on appeal. I am not saying.
But this sort of a writ petition. Now you are questioning here in your interlocutory application the order passed by the learned single judge. Yes, you are questioning.
No,
I can show you.
Yes, yes.
I can show you.
5929.
Come to page 19.
Yes.
Page 18, para 19.
Yes.
A demarcation has been ordered.
A demarcation has been ordered.
That is final.
Yes.
That is final.
2 things.
Now come to para 19, page 80.
My lord, 3 things has been said, my lord, with great respect, my lord. 1, demarcation to be carried.
No disturbance.
No problem. But the possession of respective parties should not be disturbed.
We have not disturbed.
And showing, my lord, the respective possession of the party. If I am not wrong.
That will be subject to the proceedings which is already there before the trial.
I think that's lot things has to be projected, which was not projected, with great respect.
Mr. Das, please come to para 19.
Yes. Para 19.
You are questioning the order of the learned singles, a coordinate bench in the writ petition.
Yes.
It is submitted that the scheduled land has no independent access except through the applicant's residence.
Yes.
Hence, any forced demarcation
Yes.
will necessarily disturb the applicant's actual settled and long-standing position. If this is the grievance, it is the order of the learned single judge that has to be assailed.
But what I am saying, I am not questioning. What I am saying.
You are,
Mr. No. What I am saying, that's why your lordship will.
We'll consider it at 2 o'clock.
I will not.
We'll consider it at 2 o'clock, Mr.
No,
Das.
yes.
We'll consider it too.
I'm a lot contempt also my particular role.
Now, why did you want to make a mention at this hour?
If it is possible at 2 o'clock,
No problem.
I just request my learned friend only, my lord, if it is possible at 2 o'clock.
Today,
No, I was, yes, today.
2 o'clock, we have fixed up certain matters. After that only. Or if you have any difficulty today, we can have it on a convenient date.
But I don't have it.
He'll also have to go through it once.
Only whatever, if there is a compliance report, there is absolutely no problem for
I
me.
am least bothered. I am only bothered with the direction passed by this court, which was found to be not done in the proper manner. Mr. Sharma undertook that he will have a matter done. I said, okay, file a proper.
I just want to ask my learned friend, without troubling your lordship, that whether any compliance, any report before this court was furnished or whether it was complied or not. That's all what your lordship will look into it.
And you also make your submissions on para 19.
Yes.
of your interlocutory application. When do you, how much time would you? Huh?
But
Okay.
only one problem, that they will go ahead with this and file, then nothing remains.
Mr. Das, even if they go ahead, they can't touch your possession.
No, that is true. They will not put the boundary erection. That's the main whole intention. I don't mind your lordship passes an order.
I
Demarcation
have
has,
asked them
my
not
demarcation-
to put any barriers, but the boundaries, Mr. Das, under the Assam land regulation,
Assam land and revenue.
regulation that
Yes.
provisions, what is this demarcation basically?
Demarcation is.
Is it a exercise in air?
No. It
That
not-
is the finality.
No.
That is the finality insofar as
Your
the
lordship
records
is-
of right are
your
right.
lordship is right. Under 22 of the statute, under the Assam land and revenue regulation, demarcation is putting some boundaries, erection and everything, my lord.
Because that is,
Now-
insofar as that act is concerned, that is final
No, why this?
between the
particular-
parties.
Why this was not done by the learned single judge?
I
It's
know.
only on the ground that possession should not be disturbed.
Right?
Like
Because
this.
there is a civil proceeding
Correct.
pending.
That is why.
That
suppose
is why
my lord-
this court had said,
No,
so even if that is done, your possession cannot be disturbed.
Yes, it will be, because
How?
they will go into my particular suit land and put. where the
Whatever it
boundary-
is, that is an
they
objection.
cannot-
Mr. Counsel, that was an objection you should have taken
No, we have.
in the
done-
writ petition.
No, they have taken that, my lord. That is the whole case.
Mr. Das, there was a demarcation already made.
Demarcation done.
Exercise was done.
Yes.
That was gone.
Yes.
That demarcation also, they went through your land.
They don't know. Maybe my circle office, they have not put any boundary erection.
Oh, that is what I'm saying.
Yes.
If a demarcation exercise is carried out
Yes.
and it is not found in the field, my orders are not complied with.
No, it is from my compliance report. Your lordship will kindly see that there is a compliance report.
Now the fact is, the first exercise they are done, they are doing it now again. Your grievance is, you cannot do any demarcation exercise because that will violate my possessory rights.
No, what I'm saying, my lord, what I'm saying, well, I don't know. I have gone through some. I am not disrespecting any courts. I am with.
Your
lordship
this
will-
interlocutory
don't-
application
don't
has
think-
the effect,
my lord, don't-
subject to what
my
you
lord,
say.
Don't think that I am overreaching any court's order, my lord. Being at
When
my
it
age,
is
I will
Mr.
be
Das,
overreaching.
when it is Mr. Das before me, when it is Mr. Das before me, I can be openly discussing an issue with him.
Definitely, your lordship can definitely.
That deliberation will be proper.
Yes.
But now my thing is, your this IA will hear you.
Yes.
This IA has the effect of questioning the very directions passed by the
No,
learned
what
single
I'm
judge.
saying, what I'm saying, that if the order has been passed by this court, that so and so demarcation has to be done, and so respective parties, they file an IA in between which I have annexed. And that is why they have withdrawn. What they said in the original writ petition which they have filed, it is only to the extent of demarcation showing on the.
He'll hear it. When?
The only difficulty is that they should not go beyond the orders passed by the court. That is what
That
I'm
if they have gone, we will take care.
beyond the orders passed by.
We
the court.
will take care. We will
Your
take
lordship
care.
Kindly note down.
We will take
They
care.
cannot, only
Mr.
one
Das, we
request.
will take care.
They want one particular humble submission before your lordship, that your lordship has passed the order, absolutely no, but they could not go beyond the order that has been passed. This is only my humble
If
submission.
they do it, I am
This is
here.
not
If
my
we are
only-
here,
my
we are
only
here.
argument
I have
is
not
they cannot.
passed any order, Mr.
To
Mr. Das, I have not passed any order. He has only made an undertaking to do it in the manner required.
No, it's okay, fine. They have no.
If
they
you read the
absolutely-
order, I am very, very careful
No,
on that day.
no, that's why I'm saying.
Okay. Mr. D. Das, Learned Senior Counsel, appearing for the respondent number, appearing for the applicant, appearing appearing for the applicant. Also heard Mr. M.K. Chaudhary, Learned Senior Counsel, appearing for the opposite party, number 1/contempt petition. Also, as agreed to by the Learned Counsel for the parties, a registry to list this matter again when?
Not on Tuesday, Wednesday, can it be?
Wednesday? This Wednesday?
Wednesday, yes.
Okay, on Wednesday, Kimantari Kupon, 28/2025, as 4 orders
Only they will not go beyond the orders passed. This is, I think, there will be absolute
We'll
no
hear it,
problem.
we'll hear it on
Your
Wednesday.
Lordship, there will be no absolute problem for, that will not go beyond the orders.
We'll
This is
hear
only
it.
what I'm
Because
requesting.
Mr. Das, I have not passed any order. That's the beauty.
No, that's okay, my lord.
I've not passed any order. I've not passed any, because I know my limitations in a contempt. I can't go beyond the order passed by the original court.
No, that's what I am saying. That I have also, I found certain, my lord, subject to correction. I found some judgment of the Supreme Court, which I like to.
Mr. Das, we are here to rectify our mistakes, if any made.
It's a matter of.
If
yes,
any made.
If
any made.
Yes.
But that if any has to be satisfied.
No, that's what I'm saying. I have to satisfy your lordship.
I may have to file another.
Let it file, let it be, you file it, absolutely no problem, my lord.
It's easy to escalate, but I feel that the orders, we have not traveled beyond our contempt jurisdiction. It was a action taken by the respondents to save themselves from contempt proceedings. Mistake. We'll see on Wednesday. We'll see on Wednesday.
I will also argue before this court. I am also arguing before.
Most welcome.
Whether that's what.
Mr. Das, this court is also learning.
Yes, we are.
So
also
we are
learning
also,
today.
we are always open.
Yes, sir,
We are always
listen to me,
open.
my lord.
I'll never be closed.
Yes.
But what I feel, I express only for the purpose so that I can get a retort from you,
No,
a
that's
response
why
from you.
I also knew when this order was passed, I looked into it. Then whether it is an order which is beyond the original order that has.
That is it.
This is number one. If
that you can demonstrate,
so whether
if you can demonstrate that,
whether-
I'll recall this order.
whether then 250 not your lordship can recall that order.
I'll immediately recall it, but you will have to show me.
Only what I'm on is that let them not frustrate that your original or that order that has been passed by putting something else which will frustrate the entire order. That's only my lord grievance.
We'll see. If they do it also, we can undo it.
This
There's
is what
no
is
problem.
important, my lord.
We'll see.
I don't want anything which goes beyond
Law. And we also, if we have made a mistake in passing that order, this is the last court who will not
That's
accept
why-
that and withdraw it.
That's why your lordship is open. That's why I am saying
open.
openly.
But what I have told you is what I tentatively think, which is for you to dispel.
No, I'll also argue. Your lordship has to either accept or you don't
You
accept.
reject. That's a different.
Yes.
But the areas which I have, which I feel that you will have to deal with, I have only placed that
I
before.
bought, because your lordship will hear it. I bought an IA before this court. What was the intention in the writ petition? Why they filed the IA for modification, variation of the original order that has been passed?
Okay, fine. On Wednesday. What idea? Wednesday is over.
Yeah, please.
Fine.
Eight for 2025.
Hmm.
This honorable court asks me whether sole respondent falls under the state instrumentality.
No, fine. We have asked you that. Another thing has come to our notice now. We are asking you whether this thing is maintainable, because this is admittedly a accident insurance, personal accident insurance, and your death you have not reflected in the writ petition to be on after an accident. So how will this be covered? Personal accident coverage is only for the purpose when there is a disability or death after an accident. It's a normal death. How can we help you with it?
Instructed that he was to accident lodge.
But you have not said that in your writ petition, madam. Today I can't accept that. So if you want, you can withdraw it for better, for some, Ms. Tisom, after, Ranu, Ms. Tisom, learned counsel for the petitioner, after attempting to argue the matter at some length, has submitted that she be permitted to withdraw the present writ petition with liberty to approach the appropriate forum for redressal of the grievance of the petitioner. Full stop. Prayer accepted. Writ petition stands dismissed on withdrawal with liberty as prayed for.
I'm deeply obliged.
20.
It is your lordship.
Well, 20 petitioner before your lordship.
Now you tell me why on the last 2 dates there was no appearance on behalf of
My
the
lord, last time it was for
2 dates.
mediation, my lord. You know, in earlier occasion, my lord, what happened, my lord, I just reached after 1 minute. I also made a prayer, but it was not perhaps modified thereafter. My presence was not recorded.
Okay, have the affidavits come on record?
No, my lord, this is the issue, my lord, not filed. And
Yes, Mr. Sharma. This is with regard to that.
Lordship, so we have received the instructions.
Hmm.
As per our instructions, we have submitted the requisitioned amount to the
Hmm.
PWD. and
But
that
they have
was
not paid.
Yeah, Lord.
Who is appearing for the PWD? You file your affidavit, we'll see.
It's because we are only the disbursing authority.
Okay, you file your affidavit because you have made those calculations with
Yes.
regard, give those details so that
My
they can
lord-
also know. Because they say they don't know because 2-3 times you have gone there.
my lord, there are some other issues, my lord.
You consider, let
yes,
the affidavit.
yes.
Mr. H. Sharma, learned government advocate, additional senior government advocate, appearing for the respondents number
1, 7, and 8.
1, 7, and 8 submits that the instructions in the matter has been received by him and the affidavit would be filed on or before. Affidavit on or before. You give me a date, Mr. Sharma, as per your convenience. But follow that date.
May I pray in the middle of September, Lord?
Why
If it
so
is- if
long?
It is not inconvenient to you.
Let us have it on, today is 18. Let us have it on by your affidavit by 10th of September. On or before 10/9/2025. The petitioner would be at liberty to bring on record his rejoinder thereto on or before 19/9/2025. Registry to list this matter again on 24/9/2025.
My lord, one important line, my lord. In the meantime, what they have done, in spite of the interim order protection of to a Miyadi Patta land, they have 5 times forcibly tried to evict us. We have filed contempt, my lord.
Mr.
The
Counsel,
contempt
you are a
fighting-
seasoned advocate. Come with a contempt
My lord.
petition, we will do the needful.
So that's my short date only I want them. My lord. They are trying, forcibly trying, till now they are trying.
If they are doing it, come with a contempt petition.
Already
Because
contempt, in spite of filing contempt, they are again going. Contempt is pending, my lord. Can it be take together, my lord? A contempt petition, my lord. It will be convenient for your lordship to decide.
along with
Contempt
contempt petition number
number 50 of 20.
50 of
25.
25. Okay.
Lordship, kindly the message.
List this matter before any other bench without me. I was there earlier.
Please, Lordship. Lordship, I have received this amount.
Who is appearing for the PHC department? What happened?
Were you filed affidavit today because there was some update instruction? A copy today, Lordship.
Today.
Yes, sir, Lordship.
Mr. You are appearing for?
For PhD department.
Mr. R. Gogoi. You are R. Gogoi or RR Gogoi?
RR Gogoi, Lordship.
RR Gogoi. Learned Standing Counsel PHC department submits that an affidavit on behalf of the respondents represented by him has been filed today. You want to file a rejoinder? Registry to list this matter again on 3/9/2025 along with the said affidavit filed by the respondents.
Our patta.
Yes.
Our patta land. 5 bigger, 3 kata, 1 lesser, my lord.
But only one katha, some lesser has
1
been.
kata, 5 lesser. Very unfortunate, my lord. We are, my
Yes, Mr. Sharma, what is this? What is your stand?
Lordship, we have not received any instructions, but from Annexure 5, page 22, during field inquiry, mismatch
Mismatch.
in.
But you get,
So, whether
this is
the
what is that mismatch? What is the exact problem? Just let us know. That much instruction. Mr. Manaf, let him get that instruction. This is only with regard to correction of that records. Let him get it. If there is something else, we'll see. Heard Mr. A. Manaf, learned
Challenge
counsel for deputy.
We can prefer an appeal before the district commissioner or.
Oh, he is before us. That much only we'll have to see.
Lordship.
Mr. H. Sharma, learned additional senior government advocate, submits that he would complete his instructions in the matter and apprise this court about the stand of the respondents with regard to the issue raised by the petitioner in the present proceedings on the next date of listing. Registry to list this matter again on 8/9/2025.
Right, madam.
Small instruction, ensure that it comes.
Please, your lordship, may I have short pass over?
Why?
Raising leg on court number 10.
Pass over.
My lord.
Oh, you are here.
Yes, sir.
Yes.
My lord, this is regarding not allowing the petitioner for procuring water, my lord. Already, my lord, this is second round of litigation, my lordship. Lordship, may kindly see the first order, my lord, passed by this, my lord. My lord, page 23. Page 23, my lord. There are 5, my lord.
Mr. Singha,
My lord.
in your earlier round of litigation, the Central Water Authority had given you a exemption certificate.
Yes, my lord.
Nothing like it.
My lord.
Because you are drawing water below that. But we have a rule in the state.
Yes, my lord.
And that rule requires a particular factors to be brought in before permission is granted.
Yes, my lord.
Where is that particular factors?
So, my lord,
You can come to the earlier order at page 25.
My lord.
Exemption is one thing, right? But this is boring of underground water. So these factors have to be taken care of. Where is your report with regard to these factors?
My lord, kindly see page 30.
Huh?
Page 30, my lord.
30.
Page 30, my lord.
This is their inability to have that
Yes, my lord,
portal.
according to them, my lord, I have to apply before this.
But what about your, how do you say that you have satisfied the provisions of section 2, section 3, 6(3), page 25. And madam, what happened to your site? You have not, it's not yet operative. Then what will happen to this studies? Who will do these studies? Mr. S. Bora. Let Mr. S. Bora come. We'll try to find out a way.
The matter relates to cancellation of my permission, my lord. Way back in 12.
Brother, sister.
Brother, sister, my lord.
Yes, who is appearing for the sister? No affidavit has been brought on record. Today, you will be filing it today. You are for 2. And who is for 3?
The municipal board, my lord.
4, okay. What happened to your affidavit? Why? You had undertaken to file this affidavit way back on 23/7, nearly 1 month back. Any problem in getting the instructions? We can ask your officers to be here, the executive officer. Week time. Okay, done. The learned counsel, your name? K. Bora, learned counsel for the respond number 2 and 3. Submits. You're filing the affidavit in a week. Give me a date. Give me a date convenient to yourself. That is more than a week. Okay, fine. Ms. K. Bora, learned counsel appearing for the respond number 2 and 3 submits that the affidavit on behalf of the respondents represented by her would be brought on record on or before 1/9/2025. First up, Mr. S. Paul, learned counsel appearing for the respond number 4 submits that the affidavit on behalf of the respondent represented by him would be filed during the course of the day. Accordingly, in view of the above submissions made by the learned counsel for the parties, registry to list this matter again on 8/9/2025. It is provided that no further time would be granted for filing of affidavits by either of the by the respondents herein. Nothing has been done till now.
No, my lord, there is a development.
Ah.
Now, earlier, my lord, the stand was because the land is enclosed, therefore it could not be.
But
given to us.
encroachment is removed.
Now it is removed.
Hmm.
Now, my lord, what had happened, we could notice, my lord, some influential people are giving, my lord, constructing boundary walls. So status quo should be maintained, my lord. Or there is already an interim prayer in our petition that during the pendency of this case, it should not be allotted to anybody else.
Where is that order?
Yes, my lord. No, there is no order, my lord. Our prayer.
Prayer.
At that point of time, my lord, because.
Yes,
the land
Mr.
was-
Sharma, what has happened?
2 minutes ago, Lordship, I had a talk with a person, but Lordship, 2 or 3 days accommodation, Lordship, so that I can bring it by way of.
Have you?
To that extent, I have
No,
no
no.
objection. Only thing is, my lord.
But have
some
you?
third party should not make construction.
Is that my telephonic instruction is that, Lordship, after 3 years, if a position is given to a person and he is not utilizing
Okay,
that land.
heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Miss R. Kakoti, Learned Counsel, appearing for the petition. Also heard Mr. H. Sharma, Learned Additional Senior Government Advocate, appearing for the respondent number 2, 3, 4, 3 and 4. Mr. Sharma submits that he would he has received part instruction and would complete his instructions.
Only telephonic instruction.
Part instructions and would complete his instructions on or before. On or before?
Wednesday or Thursday, Lordship, as because some.
No, some constructions are going on.
Okay. On or before 21/8/2025. Raised to list this matter again on 22/8/2025. Full stop. It is provided that in the event there has been further constructions, in the event the land in question has been allotted to any other third party, and constructions have been effected by them over the plot of land in question, further orders as would be mandated in the matter would be so is passed on a receipt of instruction on Mr. H. Sharma, apprising this court of the stand of the respondents in the matter.
Lordship is fixing on 21st.
22nd.
22nd.
Friday.
Right.
Lordship.
Is awaited.
That was the prayer on the last occasion. Huh?
We filed our amended cost item.
Ah, you have filed. Yes, madam. The matter is settled. He has to be given. Now, why the delay? Yes. You have been given already. You had undertaken, Mr. Das. Ah.
Only on 11th, Your Lordship. So
11th. Why? Why? Mr. Goyal, now what can I do? Order was passed on 4th. A copy was directed to be given to them. Mr. J. Das and Miss J. Rajkumari, Learned Counsel, represent Ms. J. Rajkumari, Learned Counsel, representing the GMC authorities, and Mr. J. Das, Learned Counsel, representing the respondents number 6 to 31, have granted further time till 4/9/2025 to bring on record their respective stands by way of filing an affidavit. Registry to list this matter again on 8/9/2025.
Except 8.
10/9/2025.
Please, Your Lordship. Lordship, I'm appearing on behalf of Mr. M. Saranya. Lordship, in this matter, we were supposed to implement a new party, Lordship. We were supposed to amend the cost title and then take steps, Lordship.
Respondent number 11.
Yes, Lordship.
Is gone.
Kindly grant us some time.
Mr.
A. Saranya, Lordship.
A. Saranya, Learned Counsel, appearing for the petitioner, submits that he be granted a week's time to file an interlocutory application to bring on to implead the
10 and 11, I suppose, Lordship.
10 is gone to implead. Gyanendra Deva Tripathi is there. He's there to implead the incumbent, the present incumbent in the post of Principal Secretary to the Government of Assam, Finance Department. Full stop. Prayer accepted. Registry to list this matter after 2 weeks along with the said affidavit. A said interlocutory application now undertaken to be filed in the matter by the petitioner. 10 also gone. 10 and 11 ko idea. The 10 and 11 hole tomorrow, yeah, about 10. 10 hobo, Principal Secretary to the Government of Assam Revenue and Disaster Management Department, comma, and Principal Secretary to the Government of Assam in Finance Department, incumbents. Huh?
Hello.
27.
Mr. Chalia, that is fine. But what the challenge in the present proceeding is to an arbitration award.
Bank account at Guwahati.
Guwahati has been done, but that is again in relation to
That is true.
award passed by this thing.
Yes.
This is under the MSME Act. Right, Mr. Cholia?
I have the intention that if the parties appear, I will take liberty from the court and to approach the original court.
I think you must approach the original court to challenge because this is beyond my jurisdiction.
Only for that, Milord, this was filed. Only for just temporarily to stay the proceedings, stay the bank account.
What do you want me to do? Dispose of giving you liberty or wait for some time?
Giving me liberty.
Mr. D.P. Chalia, Learned Senior Counsel, assisted by M. Roy, Learned Counsel for the petitioner, and Miss A. Bora for and Miss M. Bora, Learned Counsel, appearing for the respondent number 6. Also, Mr. D.P. Chalia, on instructions, has submitted that he be permitted to withdraw the present petition with liberty to approach the appropriate forum for assailing.
Before additional district and session judge.
Wherever it is, appropriate forum for assailing the order impugned in the present proceedings. Also, prayer is not objected to by the Learned Counsel for the respondent. In view of the above position, the present writ petition stands dismissed on withdrawal with liberty to the petitioner as prayed for. Will do, Mr. Chalia. Something more?
And the stay order against that will continue till life.
So and so within a period of with liberty granted to the petitioner to approach the appropriate forum for assailing the impugned order impugned in the present proceeding within a period of 45 days from today till the period of 45 days, comma, the interim order passed by this court wide order dated 15/12/2021 shall continue to subsist. List this matter before any other bench without me. I can't.
Please, Your Lordship.
Yes.
Impleaded.
But madam, you have impleaded, you have filed an amended cause title. Now you'll have to take steps for service of notice. Heard the Learned Counsel for the petitioner. Also, the Learned Counsel for the petitioner is directed to take steps for service of notice upon the newly impleaded respondent number 2, right? Respondent number 2 by way of registered post with AD steps within 3 working days from today. Registry to list this matter again after 4 weeks.
80 and 81.
Please, Your Lordship.
Yes, Mr. Gugui.
Yes, as per the last order dated 17/3 passing IA, that cost title has been already corrected and steps have been taken.
Anybody appearing for Mr. Huda? I think Mr. Nayak appears. Housing and
yes, urban development.
Urban development. Huh? Who is Mr. No. That is for the housing board. Who is for the Commissioner and Secretary, P9. Is he available? Can you just get him so that we can clear this up? Otherwise, matter is pending because of this only. Urban and you appear for housing and urban development.
Urban affairs.
Urban affairs. You can appear. Yes. Heard Mr. I. Gogoi, Learned Counsel for the petitioner. Also heard Mr. S. Bora, Learned Standing Counsel, Department of Housing and Urban Affairs, and Mr. N. Das, Learned Government Advocate, appearing for the respondent number 2 and 3. Mr. S. Bora, Learned Standing Counsel, and Guwahati Municipal Corporation. Respondent number 4. Respondent number 1 and respondent number 4. Awesome. The Learned Counsel for the petition shall furnish a copy of the writ petition along with its annexures to Mr. S. Bora, Learned Standing Counsel, Housing and Urban Affairs, Learned Standing Counsel, Department of Housing and Urban Affairs. Also, during the course of the day. Also, Mr. Bora to complete his instructions by the next date of listing and apprise this court of the stand of the respondents with regard to the issues raised by the petitioner in the present proceeding. Full stop. Registry to list this matter again on when, Mr. Bora? 3 weeks for this small matter. This is only the garbage has to be removed from his Miyadi land. And if you're having it, acquire it.
Also want that take that particular land, you take it.
Yes,
This is the-
yes,
Yeah.
that's all.
That
You
will
pay
be
the
the-
compensation.
You pay the
take it.
compensation, that much.
Okay, that's all, Your Honor.
So that will be from the deputy commissioner. We cannot.
No. The GMC has to be, GMC is doing it.
But to acquire that land is not, GMC will not go and acquire the land. It have to be.
No. If you want, see, the decision has to be, you will be the requiring agency. They will be the acquiring agency. But the requiring agency has to say, you give me, Likha, complete his instructions in the matter. So, Mr. Complainant apprise this court on the next date of listing. So, register, I'm giving you a short date. Register to list this matter again on 29/8/2025. Just that much only. Any problem?
I have a matter in Arunachal.
When do you want? When do you want?
Next day.
Let it be on third.
Yes.
Third.
Yes.
We don't want to prevent Mr. Gogoi from going to Arunachal.
Chief, much obliged.
39 koi dia. Just get me that instance. Should I specify? Need not be. Everything completed? Yes, who is appearing for the respondent here?
It's from respondent number 3, my lord. That is 21/11.
Assam Petroleum Limited, who is appearing? Anybody appearing for Assam Petroleum Limited? No.
That day somebody has appeared.
Who is appearing? S. Sharma, R. Hajorika, BP Sharma. Can you get them? Because your case is that the PF dues were deducted but not deposited. So that clarification only we require. Get that. ESI benefits you are not going to get back. Because that is there in the hospital, you can go and avail. But PF, you will have to.
As per the court's order, my lord, of 21/11, my lord, I have to take steps on respondent number 3 because some mistakes was there, my lord. So Provident Fund officers are required, I think. Whether
But
that was deposited or not.
Okay, Mr. M.K. Sharma, Learned Counsel for the petitioner, submits that he be granted 2 days time to take steps for service of notice upon the respondent number 3. Prior accepted, register to full stop. Petitioner to take steps for service of notice upon the respondent number 3 on or before 21/8/2025. Full stop. Register to on receipt of the requisites to issue notice accordingly. Full stop. Registry to list this matter after 4 weeks on a date to be fixed by it. MK Mishra. Marbo Mumbai.
Next day, some.
83.
It is your lordship. Lordship, the vehicle. Last order, lordship. They were required to file an affidavit.
Today, everybody, you have stopped them from coming to court. Huh? How will they file the affidavit? Mr. Betala is very powerful.
May not be, lordship.
Nobody is there.
My lord, the order is powerful. Lordship may have a look on the last order passed by my lords.
Yes, where is Mr. Gugoi? D. Gugoi. Forest, get somebody from the forest. We'll do something.
Proceed in this case, today we have taken steps.
Who is appearing for the excise department here?
Gugoi was here.
Can you get him? Get him. It's only that it went to wrongly recorded mistake, typographical error. We'll correct it. Get Mr. Gugoi. This is that Sanjay Jalan matter. Reconstitution. I think I have appeared. I have appeared in this matter. Yes, Islam was there earlier. I think I have appeared in this matter. Yes, I have appeared because this matter facts seem to be so Sanjay Jalan, then the other one is Rajesh Jalan. List this matter before any other bench without me. It looks very familiar. And there were some appeals also in the meantime.
There was a division.
It's with regard to constitution of that retail outlet. It was not done. Then you were supposed to send it on holiday list. Then it was allowed to be run by one of the brothers, for which he has I know this fact very nicely. I should not be appearing. When I saw the name, I did not read the file. Okay, fine.
Get.
Standing line.
Yes, where is Mr. Hendik? None appears for the parties even on second call. Full stop. It is seen that there was no representation of the petitioner when the matter was taken up on the last dates of listing, that is on 11/3/2019 and 11/5/2022 and 14/7/2025. So, in view of the above position, the present petition stands dismissed for non-prosecution. Yes, madam.
Here, my lord. Terms of the tender notice, lordship, page 13. Big to collect toll tax from the vehicles carrying lordship, sand, soil, boulder, etc. within the municipal area of.
Have you, what is your stand against para 9, 10?
I have replied, lordship.
Okay, what is your stand?
Your lordship, firstly, lordship, I want to be very specific regarding the tender notice. My business regarding collection of toll tax is specific towards collection.
Madam, that is the problem. You are not correcting, you are not a toll gate. You are a market. You come to the advertisement.
That is true, lordship. But there
Market of boulder, stone, sand, soil, etc.
Lordship, that was incorrectly incorporated.
So where is that statement of yours that this was an incorrect?
That I have abandoned in my in.
No, in your writ petition, where is that?
Writ petition, there is. Yes, but in affidavit in reply.
So
made a categorical statement.
It's not a gate when it's projected as a market, and the affidavit also says that this is a market wherein goods from these two mahals also come, and the mahals are only silt mahals, sand mahals.
subject to correction, Lordship.
Okay.
Lordship,
Ms. Tison, learned counsel for the petitioner, submits that the affidavit in reply on behalf of the petitioner has been filed and is tagged with the records of the present and is tagged today with the records of the present matter. Full stop. In view of the above, the pleadings being complete, registry to list this matter again on first week, what date? First week, second week, 9/9/2025. An endeavor would be made to dispose of the matter on the next date of listing.
I'm obliged, Lordship.
But this aspect you will have to
Yes,
be
Lordship.
very clear.
I'll clarify, Lordship. 19.
Yes. Oh. In more table or side or Jaspal Singh Bule or Vinod Kumar Bule, the judgment was it. Yes.
Leave it to your lordship, my lord. Before
Okay.
that, my lord, only I point at page 6, paragraph 2 only. First, second, 2 lines. That a petitioner being river eroded landless people who are residing on the government land covered by the number so and so of village so and so.
And that government land, Vijaya land is also government land. Vijaya land is also government land.
But that not.
Heard Mr. B. Rahman, learned counsel for the petitioner, also heard Mr. H. Sharma, learned additional senior government advocate, appearing for the
3, 4, and 5.
3, 4, and 5. Respondents number 3, 4, and 5, and Mr. Upod Lihibai, A. Bhattchaji, standing counsel, Revenue Department, appearing for the respondent number 1 and 2. The petitioner in the present proceeding has prayed for a direction upon the respondent authorities for issuance to them of pattas in respect of the land allotted in case of the petitioner, allotted to the petitioners individually by the respondent authorities under DAG number 157 bracketed part of village Khatoni Bari under Naharoni Mungza of Thelamara Revenue Circle, Sonitpur district. Also, the petitioners in the present proceeding have contended that they, being river eroded landless people, had occupied the government land covered by DAG number 157 bracketed part of village Khatoni Bari under Naharoni Mouza in the district of Sonitpur. Also, the petitioners further contend that they were allotted individual plots of land by the respondent authorities sometime in the year 1992. Also, the petitioners since their date of initial occupation of the land in question have been continuing to possess the land involved. Full stop. The respondents having not issued the pattas to the petitioners, they have instituted the present proceeding. Mr. B. Rahman, learned counsel for the petitioners, have reiterated the facts as noticed herein above and has also submitted that the petitioners' possession of the land in question for a long period of time is not disputed. However, the respondent authorities have denied issuance of pattas to the petitioner for reasons not disclosed. Also, Mr. H. Sharma, learned counsel for the learned additional senior government advocate, appearing for the respondents. State respondents have submitted that the land covered by DAG number 157 of village Khatoni Bari, Mouza Nohar Bari under Thelamara Revenue Circle, Sonitpur district is reserved as a VGR land, village grazing VGR land, and accordingly, in terms of the decision of the Honorable Supreme Court in the case of Jaspal Singh and others versus State of Punjab and others, 2011 bracketed 11 SCC 396, no settlement over the said land is permissible to be made. Accordingly, the petitioners herein were not issued with the pattas. Full stop. I have heard the learned counsel for the parties and also perused the materials available on record. The petitioners in the petition have contended that the villages wherein they were so residing having been eroded by the river and they having been rendered landless, they had proceeded to occupy the government land covered by DAG number 157 bracketed part of village Khatoni Bari under Naharoni Moza in the district of Sonitpur, Assam. While the said statement has been made in the writ petition, there is no further disclosure from the petitioners that about the disclosure in the writ petition about the villages wherein the petitioners were so residing before being affected by on account of river erosion. Also, the petitioners have admitted that they are occupying DAG number 157 part of village Khatoni Bari under Naharoni Moza. Also, the respondents in their affidavit have raised a categorical contention to the effect that the land covered by DAG number 157 bracketed, which is possessed by the petitioners bracket over, is a VGR land. Full stop. The said contention was raised in the affidavit filed on behalf of the Deputy Commissioner Sonitpur, Tezpur on 27/2/2020. Full stop. For the last around 5 years, the petitioners have not disputed the said contention made in the affidavit by the respondent number 3 by way of filing a rejoinder. Full stop. In view of the said position, the land in question being a VGR land, in VGR land, and the Honorable Supreme Court in the decision of in its decision in the case of Jagbal Singh bracketed Supra, having categorically directed that such land would not be permissible to be so settled with an individual, this court is not in a position to accept the contentions made by the petitioners in the matter. Accordingly, the present writ petition would not mandate an acceptance. Accordingly, the reliefs sought for in the present writ petition would not mandate an acceptance. Full stop. In view of the above position, the present writ petition stands dismissed. Present writ petition is held to be devoid of any merit, and accordingly, the same stands dismissed. However, dismissal of the present writ petition would not bar the petitioners to approach the respondent authorities by disclosure of all relevant particulars for being allotted a plot of land in terms of the land policy governing the field as on date. You approach, disclose, get it.
Tree.
Yes, Mr. Kathar. What is your grievance?
We have not received.
Okay. Once I give you that copy, what will you do?
Lordship, then I can go to the arbitrator, Lordship.
Okay. Mr. Chutia has submitted that if you pay a ₹10 to the competent authority, the details would be furnished to you. Awards would be furnished to you. So if that be so, your grievance is redressed?
Yes, Lordship, in part, Lordship. One is my first prayer is visual award. Second is Girard valuation sheet. Third is that, Lordship, some amount has been paid to us, but since we don't have the award, we don't know if there is still pending amount. That also should be paid.
And you want enhancement also?
Later, we will go for enhancement
for
the arbitrator. Lordship.
Who is the authority? No, give me that. Kala is there. These poor people will know now. Give me the designation of that authority.
Designated as competent authority for land acquisition, that is
Joint Secretary,
Department of Revenue. Individual award of 14 petitions.
Revenue, Department of Revenue, Caribbean Autonomous Council. The petitioners heard Mr. Ek.
10 rupees council.
That we'll say. We'll not say 10 fee of the council. Ms. Heard Mr. A. Kathar, learned counsel for the petitioners, and Mr. J. Chutia, learned standing counsel, Karbi Anglong Autonomous Council, appearing for the respondents number 3, 4, 5, and 6. No. 3, 4, and 6. And Ms. R. Bora, learned standing counsel, NHIDCL, appearing for the respondent number 5. And Ms. M. Borman, learned government advocate, appears for the respondent number 2. It will be ID. Full stop. The petitioners, by way of instituting the present proceeding, has prayed for the following reliefs. A to A, page 22. Also, a perusal of the relief sought for by the petitioners would go to reveal that the petitioners primarily are praying for a direction upon the Joint Secretary, Department of Revenue, K. Karbi Anglong Autonomous Council, bracketed KAAC, that is the respondent number 4 hearing, to furnish to them the individual awards as passed in their respective cases for the acquisition of their land. The petitioners have also prayed for a direction for furnishing to them individually the Girard valuation sheets, report of the petitioner's assets, etc., as assessed during the survey preceding the acquisition process. Also, the petitioners have thereafter paid that the remaining that they were the responding to the said prayers made by the learned counsel by the petitioners in the matter, Mr. Chutia, on instructions, has submitted that the awards, individual awards as drawn in respect of, as passed in respect of each of the petitioners are ready, and certified copies thereof can be furnished to the petitioners on remitting the counsel fees as applicable, as prescribed in the matter. Mr. A. Kathar, learned counsel for the petitioner, has submitted that the petitioners would approach the respondent number 4 with an application in this connection, along with the prescribed fee, and on such for being furnished with the individual copies of the RPAR, along with the Girard valuation sheet, a report of the assets of the petitioners assessed during the assets of the petitioner assessed during the survey as carried out in the matter within a period of 2 weeks from today. In the event the petitioners so approach the respondent authorities by way of submitting individual applications, the respondent number 4 shall furnish to the petitioners the individual awards as passed in respect of the lands acquired of each of the petitioners herein, along with the containing the amount of compensation so determined in their respective cases. Full stop. The respondent number 4 shall also furnish to the petitioners the Girard valuation sheet, along with the assessment report of the assets of the petitioners so acquired. Also, within a further period of 1 week from the date of receipt of individual applications from the petitioners herein. First, on receipt of the applications, on receipt of the awards as well as the Girard valuation sheets, in the event the petitioners find that the amount of compensation already released to them is only a part of what has been awarded in their respective cases, the petitioners shall submit an application before the respondent number 4 for being authorized the remaining balance of the compensation amount so computed in each of their cases. Also, on receipt of such application, the respondent number 4 shall consider the same, and if it is found that further compensation amount, found that the compensation amount as awarded to the petitioners have not been released in full, shall take steps for a release of the said amount in the manner prescribed within a period of 1 month thereafter. Full stop. In the event the petitioners are aggrieved by the by the amount of compensation so authorized, so awarded to them, they shall be at liberty to approach the respondent number 4 for reference of the matter to the arbitrator appointed by the central government in the matter.
Receive the compensation or person who is paid. They are not agreed, my lord.
But here, who is
Arbitrators,
no, who will refer? Who will refer? Who is the authority to refer?
petitioner, if he is,
Petitioner will be at liberty to approach the arbitrator appointed in the matter by the central government,
state government.
by the state government. Designated arbitrator, full stop, quote area. With the above observations and directions, the present writ petition stands disposed of.
7.
Yes. Yes, Mr. Singh.
My lord. Lordship kindly peruse the, my lord, agreement, my lord. Page 25.
Page?
Page 25.
27.
25, Annex 5. This deed of agreement is executed on 2/1/2024 in the in respect of.
So this agreement, your statements with regard to page 21 is wrong. Your, sorry, page 16 is wrong. Further, your statement in the reply at para 8 is wrong. Both cannot be correct. Either one will be correct. And this is a document you have brought on record in the writ petition. So, contradictory stance.
The agreement, my lord, between the parties.
If he was here, the Dhandar Borua was here, we would have considered that. He's not here before us. So under
Facts remains that his amount he received, my lord. I
know.
I paid him.
I know.
And this is the amount I am entitled to.
But Mr. Your own statements have made the confusion.
Withdrawing, my lord, my reply, my lord, then. My lord.
You can't.
Not press, my lord.
You can't. Okay. Yes, Mr. Soma, what is the way out?
We are suggesting him to return back the check. The calculation was he is entitled to, he will get it.
This is my exclusive amount. I have paid the amount to
If he is
the
entitled
non-prosecutor,
to, pay to him.
as per the agreement, my lord.
Okay, go before the civil court or the competent authority under section 76.
Petitioner is 85 years old, my lord.
Okay, Mr. I'll settle it. Mr. PJ Soikia, learned counsel for the petitioner, is directed to implead the co-patadas in the matter. Such impleading application be filed within a period of 1 week from today. Full stop. Raised it to list this matter again after a week along with the impleading application. Now undertaken to be filed. Now directed to be filed by the petitioner in the matter. Just get him. We'll get him here. Finished. You should have brought him on record in the first place only.
The agreement is there. That's why I'm not.
Agreement, Mr.
Soikia.
I understand. That is why I did not dismiss your writ petition. Your case is that, see, this is an amount may be receivable by many, but it was given to me. I have paid that amount, right? I have paid that amount. So this amount will only come to me. But unfortunately, that is not the case you have made out. Either in the writ petition or in the affidavit, in the reply. You say this is only my account and the respondents are now taking plea that there are other people. There is agreement between you and the co-patadas which you have brought on record. There is page 25. agreement, then how could you have taken that plea in the reply?
I'll do, my lord.
You bring it, we will solve it.
71.
As regards your lordship's query about page 35, I have just got the instructions because in my affidavit, it is the vernacular is the white paper, I don't know. But it was said by my clients, my lord, that it was about the position they will acquire in the land. So, my lord, another aspect of the matter is that section 64 says there is an outer limit for the collector to send it to the authority for 6 months. Otherwise, after 6 months, I can approach directly to the civil court. That might approach. My lord, only thing that my prayer is that, my lord, your lordship may not write the word dismissal. And another aspect, my lord, there was an interim order up to 2011-24. That outer limit of 45 days may be given. I will approach there, my lord. That interim order may be continued till then, my lord. 2011-24, that amount may not be disbursed. That was like that. Some order was there, interim order.
But you are interested only with regard to 2 lesser. But subject to correction, you are interested only with 2 lesser. Why should we continue with this interim order?
My lord, because I am not concerned with 2 kata, because they are saying at page 22 that we are all the pattadas. Only as regards the position, they are holding 1 kata. That is why they are paid more. Page 22. Competent, my lord, the affected parties, the word owner comes prior to position. In the my lord, definition of affected family is different and affected parties.
Mr. Chaudhary,
My lord.
the provision of section 64 is different and section 76 is different.
That is a reference.
76, there is no recalculation of the compensation amount.
No, only that regarding apportionment.
Apportionment. Now, here to the authority. Now, who is the authority?
Authority, my lord, as per in the state government.
Yes, Mr. Sharma, who is the authority?
Civil court. That judgment, what I find, my lord,
A judgment is...
Okay. Where my lord, there was a statement where it is stated that under this act, it is an admitted fact that the district judge is the authority. My lord, at para 6, there is no dispute to the fact the district judge of the respective district have been designated as the authority under the Act of 2013, para 6.
This is not a decision on section 76.
Not a decision on this.
Not a decision. Yes, Mr. Sharma, who is the authority under this act of... In the National Highways Act, it is the principal. Principal. Who is the authority here? Because this is not a decision on... It's an appeal filed under section 74. That is different.
Only at that line, what I...
Mr. Sharma, can you get that instruction? Section 51.
51 as regards, who is that competent authority?
No, that is a different authority altogether. This is with regard to the pre-stage. When there is a dispute with regard to the land and all those things, then 51 will come in.
And as regards civil court, there is a
No. We'll have to be very clear. Mr. Sharma, can you get this information by Wednesday or Thursday?
Thursday, my lord, may not.
Thursday.
The BTC authority, I have received the instruction. Chapter falls under them.
Okay. Yes. Who is the competent authority for apportionment under section 76? You have your instruction. That oral instruction will do. We believe Ms. Bora. We don't want anything written. Just take that. Who is the authority? We will refer the matter to them.
Well, on Friday.
Monday. Tuesday. Heard Mr.
Interim order to continue.
Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Also, Ms. R.B. Bora, learned standing counsel, BTC, appearing for the respondents. Tuesday. Appearing for the respondents number. You are for respondent number 2, 3. District Commissioner, you will not appear. You get it from the District Commissioner. Appearing, heard Mr. A. Bhattchaji, learned. Upar likhi na P.K. Roy Chaudhary. Also heard Mr. P. Bhattchaji, learned. Standing Counsel, Revenue and Disaster Management, appearing for the respondent number 1. Ms. R.B. Bora, learned Standing Counsel, BTC, appearing for respondent number 2 and 4. And Mr. H. Sharma, learned Additional Senior Government Advocate, appearing for the respondent number 3. Mr. M. Rahman, learned counsel, appears for the respondent number 5. On the next date of listing, Mr. Bhattchaji as well as Mr. H. Sharma shall apprise this court as to the designated authority under the provisions of Section 76 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Registered to list this matter again on 26/8/2025 for further hearing.
Interim order.
Interim order passed earlier to continue till the next date of listing. Mr. Sharma, Mr. Bhattchaji, you will also have that. Either of you, that instruction. Who is the authority?
21.
Case Lordship, on earlier occasion, we took time to file reply, Lordship. Respondent number 5 already filed affidavit in. The reply is ready, Lordship, due to some his personal.
Okay, let him rest. Now your case here is simple. That you had entered into an agreement for sale with your father. Respondent number 5, he is still a father. So I'm using the term father. That this land we are going to buy from you. You paid him also some amount.
That and title suit is pending. Injunction is also there.
Be that as it. Some amount you have paid him. But although an NOC was applied for, that sale deed did not occasion. So under the Transfer of Property Act, I think Section 57, the property transfer has not taken place. So how do you claim?
Decision of the title suit.
That is for you to take up before the title suit, not here.
Lordship,
Here you don't have any right over the property.
I am against the impugn order, which is kindly see page 36, Lordship. That is in the order, Lordship, the learned passed an order.
Rightly so. Rightly
Change
so.
the land compensation amount to dispute, Lordship. But Jira.
How can you? Because we'll have to see what your status is. You entered into an agreement for sale, but that was never carried forward within the time frame prescribed.
Lordship.
So that is gone. If you have anything to do with that, within that period, you could have gone for a specific relief thing, which you have done. Whatever happens there will happen.
Amount was
Gone is
disbursed,
gone.
Lordship.
You will have to take an injunction from that.
As per
But I don't think the injunction would also be permissible here.
Injunction is operating.
What is
In
that
the
injunction?
meantime, land was acquired. Lord.
What is the injunction?
Status quo is to be maintained, Lord.
Maintain.
Yes. That I have enclosed along with this writ. But Lordship, as per Vinod Kumar, Supreme Court says, Lordship, the ADC has no authority to decide the objection, Lordship. He has to refer it to the competent.
No, when there is, if the objection is in only form, not in substance, why should he do that? And see, very categorical statements in the respondent number 5's affidavit. That there was a failure. on your part to purchase the land. Maybe you have now gone up before the civil court, that let it specific relief act. Let it take.
Till the decision, Lordship, I am only saying that in fact, Lordship, the
Why should we prevent him?
Page 31, Lordship, injunction order. Hence, for preservation of the suit property, both the parties are directed to maintain status quo as to the status of the scheduled land, its nature, right title and interest, as on today till the disposal of the main suit. Further, parties are strictly directed not to alienate the same to the third party without leave of this court. In fact, Lordship, entire property was purchased by the petitioners, and only after second marriage, my father denied our right, Lordship. For that only the dispute.
That is an issue which will be decided in the trial of the suit that you have instituted.
As per impugn order, page 36, whereas since there is a dispute about the land acquired as well, hence land compensation has been kept in abeyance.
Where?
Page 36, Lordship. Case record put up before me today. First party remained absent on both first and second hearing. In fact, we have prayed for another date that was not given to us, Lordship. I have enclosed my petition. Second party present on both the dates, whereas since there is a dispute over the land acquired at
Who is this Asabuddin Barmiya? Okay.
So he may be paid the Jirat compensation as per 3G award list. So his Jirat was allowed to be disbursed, but on land compensation directed to be remain in kept in abeyance. As per 3H, Lordship, it is any dispute regarding apportionment and to whom it may be transferred.
So, Uddin, what do you say?
This is not case for the title suit was
agreement.
Now, what have you done in pursuance to 2012-2024? Have you challenged this order? Then? So a dispute is apparent. You have also accepted that. This is under the National Highways Act.
Page 4, if any dispute arises as to the...
Vinod Kumar.
Yes, Lordship. This Vinod Kumar says paragraph 33 and 34, Lordship. It's already in the file, second file.
No, I have a copy. It's 2319 SCC.
Page 12, paragraph 30.
But this same very issue indirectly is pending in the suit that you have.
Purchase of that property.
So if there is a declaration that you are the owner of that plot of land, then the entire compensation will come to you.
Till the decision of the suit, the money may be kept in fair amount.
That can be thought of. Yes, Mr. Uddin.
By setting aside this order, direct the matter to the...
Also, the heard Mr. R. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. H. Sharma, Learned Addition.
No disbursement. Finally,
No, I'm referring it to the, asking the Kala to refer it to the competent authority, which is the principal to decide of this. But again, that will come in conflict with the title suit that is pending.
No disbursement.
Till the also. Will not be, we'll direct that. Also, heard Ms. R. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. For respondent number 1 also, madam. 1 and 2. Heard Mr. R. K. Talukda, Learned Counsel representing the respondent number 1 and 2, and Mr. H.K. Sharma, learned additional senior government advocate appearing for the respondent number 3 and 4, and Mr. G. Uddin, a learned counsel representing the respondent number 5. The petitioners in the present proceedings, by projecting that they had brought a plot of land from they had entered into an agreement for sale for a plot of land covered by
Tag numbers and patta numbers we have reviewed.
Measuring 15 katas covered by different dag numbers and patta numbers under Mauza Saidpur in the district of Kachar from the respondent number 5 with the respondent number 5. Also, the said plot of land brought by the for which an agreement for sale was executed between the petitioners and the respondent number 5 was acquired by the respondent authorities under the Bharatmala project. Also, thereafter, it is seen that with regard to the said amount, with regard to the said plot of land so acquired, the compensation was land compensation as well as Jirat compensation was assessed under Section 3G of the National Highways Act 1956. First, the respondent number 5 being the pattada of the land in question, the compensation, in the list so published, the name of the respondent number 5 was denoted therein as the person to whom the compensation is to be so released. First, the petitioners herein raised an objection with regard to disbursement of land compensation value to the respondent number 5 by projecting that they had already entered into an agreement for sale of the land in question. The competent authority for land acquisition, bracketed Kala, that is the additional district commissioner, Kachar, on consideration of the matter of the issues raised by the petitioners and the respondent number 5, proceeded to pass an order dated 20/12/2014. First, while the said order dated 20/12/2014, noticing the dispute of the land acquired, the land compensation so assessed in respect thereof was directed to be kept in abeyance. However, the respondent number 5 herein, being the recorded pattada of the land in question and he being in possession thereof, the Zirat compensation as per the 3G award list was directed to be released to him. Also, being aggrieved, the petitioners have instituted the present proceedings. Ms. R. Chaudhary, learned counsel for the respondents, have submitted that the respondent number 5, having not executed the sale deed, and further by contending that the land in question was actually brought in the name of the petitioner, of the respondent number 5, by the petitioners herein, they have instituted a title suit, being title suit number 190/2022 before the court of the learned Munsif number 1, Kachar at Silchar, and the same is pending disposal. Also, it is also highlighted by the petitioners that while an order dated 28/2022, the trial court had directed for maintenance of status quo with regard to the land in question. Also, in view of the above position, both parties agree. You also agree, Mr. Uddin? The parties to the proceeding have agreed that the land Zirat we are releasing. Zirat he will get. Land compensation only.
Already land compensation was kept.
Submits that the land agreed that the land compensation as well as the Ziraat compensation as assessed for the land in question be kept in abeyance until a decision is arrived at by the trial court in title suit number 190 of 2022. Full stop. In view of the consensus reached by the parties to the proceeding, the present petition is disposed of, directing the parties, directing the additional CALA, C-A-L-A, that is the respondent number 4, not to disburse the assessed land compensation as well as the Ziraat compensation to either the petitioners or the respondent number 5 pending a decision of the trial court in title suit number so and so 180 about so and so, full stop. The compensation would be released, would be released to the person designated by the trial court in the proceedings of so and so on conclusion of the same. Full stop. It is reiterated that till a decision in the matter is rendered by the trial court in title suit number 190/2022, the respondent number 4 and or any other authority empowered in this connection shall not release either to the petitioners and or the respondent number 5 the land compensation amount as well as the Ziraat compensation amount as computed, as assessed for the land as acquired over which a dispute is pending between the petitioners and the respondent number 5. With the above observations and directions, the present petition stands disposed of.
Deeply obliged.
आरामत मारना काली राती पर निकले हो आरामत किने भूल न कोई आरामत पाएंगे. Yes, Mr. Bora.
But I have this, but it's not clear whether some ways like
What not clear? Well, you, Mr. Bora, as a GMC authority, do you license the boring or you license the trade? You're not licensing the boring, right? Yes.
My lord, as per the order of this honorable court.
Who is appearing for this authority, state authority? I think it's the irrigation department.
My lord.
Who is there for irrigation?
My lord, irrigation is.
Have you made anybody a party?
No, my lord.
You have not made any a party. The GMC is only with regard to the trade of that water. It cannot be the boring.
In fact, the GMC is not a party. Party municipal is unacceptable.
It's not a party. Yeah, we'll give that liberty. But how can this be?
My lord, I will implement the my lord, state authority, my lord. But my prayer is already in the order of the first round of litigation, my lord, they approach the state authority. And there is certain condition is there.
Now that state authority is not operating.
Yes.
Shall we permit you to extract water?
Then, my lord,
and that too,
again,
Mr. Sinha,
my lord.
in the city of Guwahati, that is a very precious commodity.
My lord.
You are extracting that in a residential area, right? Where has the study been done? Or where is the report to show that your extraction will not affect the other residents of that area?
Yes, my lord, this is already observed, my lord. I have to procure all this permission, my lord. Now, my lord, here kindly see, my lord, page 25. Page 25, my lord, here, it is on para 3, it is, my lord, it is already observed that on receipt of the application under.
What happened to that authority thing? Page
25, my lord.
Page 30. Because the Central Water Authority had only granted an exemption to him.
My lord.
Lordship will see at page number 21, what central government has granted. Central government has granted him to withdraw water of less than 10 cm per day. What is 10 cm? 1 cm equal to 1,000 liters.
30,000.
Do business with this.
30,000 liters.
If the state central government, no, he will not be able to do business with that, this amount, 10,000 liters per day. And he have to keep a logbook also. He cannot do business with this.
Who is there? You implead the irrigation department and the authority. Mr. K. Sinha, learned counsel for the petitioner, submits that he be granted a week's time to implead the irrigation department as well as the competent authority empowered for control and regulation of groundwater in the state of Assam. Also, let the said application, interlocutory application, be filed within a period of 2 weeks from today. Registered to list this matter again after 2 weeks along with the said interlocutory application. Because Mr. Sinha, they are only concerned with the trade. They are not concerned with the...
My lord, what I have instructed, my lord. Now everybody is running this from taking license from the GMC. My lord.
That is an error. Mr. Bora, this is going to be very dangerous.
Can you see? This is the recent license, my lord, granted to me from the GMC.
Online license, they are doing it by showing that this is saying a business. This is online.
No, the business is permissible. I'm not saying that. The business may be permissible.
No, this license.
But where is that
this
requirement?
Is license, my lord, not an individual license, my lord.
Okay, fine. We got it. But that is to sell the water.
Yes.
Not to bore. Something different.
License was applied, my lord. It is already mentioned that this is for boring.
I got it.
And accordingly, my lord, they inform us before filing this case. That
Mr. Bora will now take up the matter with the GMC authorities and get a redressal, because this will affect all the citizens of the state.
After there are many, all these things are stopped, my lord. Now, who is running it? Except this one.
But that will not affect because the river is nearby.
Yes.
So the accumulation of the water is taking place. But what would you do in say, towards the center of the city, if the water is permitted to be very dangerous? Okay, fine. My only query is that where has the parameters set out in the state law satisfied? An exemption is not satisfaction of those. Do you get my point?
My lord, my lord.
83.
He was on legs in 19.
We'll have it on Wednesday. Friday. Heard Mr. H. Betala, learned counsel for the petitioner. None has appeared on behalf of the respondents in spite of, even on second call. Registered to list this matter again on, for the ends of justice, registered to list this matter again on Friday. Yes, madam. Mir Gugoi was appearing, so we'll have to drop a contempt proceeding today. You have not filed an affidavit. And he be on leg, but where is the affidavit? Affidavit is not with him on the legs. He is on bereavement. What has happened? Oh, I'm so sorry. Lekha, I'm so sorry. I did not know about it. I was told that he is on legs. I'm really sorry about it. Heard Mr. H. Betala Thegil. It is submitted in the bar that Mr. D. Gogoi, learned counsel representing the respondents, is in bereavement and as such not in a position to appear before this court. Registered to list this matter again after 3 weeks. When did his father die? 2 weeks, 3 weeks, on a date to be fixed, right?
Need be.
Enough.
Well, I shouldn't object on that. I was informed that he didn't pick up my call.
Okay,
I informed RR Gogoi.
but anyway,
Need be. I'll leave it to my
anyway,
I shouldn't.
once that is the ground, this court at
shouldn't.
least will not come.
Definitely, Lordship. I would not.
Anyway, my condolences, I'll express it myself to him. Don't.
Obliged, Lordship.
84.
RR Gogoi is on legs and
Will he appear for the tender bid committee? No, madam, you see, respond number 5. That is the whole problem. It has been created.
to what your Lordship might find.
So, 5 is a DC, chairman of a tender committee.
Hmm. 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 So you are continuing with the operations? You continue. Who has stopped you? Nobody has stopped you. This 2 lakhs is a statutory payment you have to make for the renewal. Madam, will you be appearing for the respondent number 5 also? It's a body created by you only. Actually, what has happened here, why this has come for orders is, there was a requirement to take steps on respondent number 5. He has taken steps on respondent number 6. Respondent number 6 is already represented. Not his error. Maybe there was a typographical error earlier. So now what do you say? Whether respondent number 5 you can appear.
They have taken step to respond number 5.
You have taken. Okay, then fine. Dekha. Mr. A. Chetri, Learned Counsel for the respondent, submits that steps have been taken. Fresh steps have been taken for service of upon the respondent number 5 today. He also submits erroneously earlier. These steps were so taken for service upon respondent number 6. However, respondent number 6 is duly represented in the present proceeding. As the petitioner has contended to have taken steps for service of notice upon the respondent number 5, registry to verify the same and act and take steps accordingly and to verify the matter and issue notices upon the respondent number 5 by way of registered post with AD. Registry to list this matter again after 4 weeks on a date to be fixed by.
Obliged.
Now you have the whole time for you.
Lots.
How to nai baki ko? Yeah. Okay. 20? 25. 25%. I was expecting this thing in the morning itself from you.
Because I thought that a lot.
No. Because this is what you have brought on record earlier. I was expecting that you will be pressing this. That is, I was repeatedly asking you, but you never responded.
Problem here, no way, Lordship, now, Lordship.
No problem, no problem. Okay. So, Mr. Sharma, these instructions reveal that this is not for the Nagaland or Meghalaya code. It is only in respect of the Assam code. Why are you creating a big issue out of that? Finished. Only thing we will say that this order would come only in respect of the TPs issued by the Assam for Assam coal, originating from Assam. The same will not have a. This is the only sentence I required from you. Are you making that sentence? Okay, if you are blank, we will not disturb you.
No, no, today not, now, no.
Now you're okay. Okay. You agree to this? Agree to this? Huh? You also agree? That much only we have to do. Yes, Madam Casey. Do you agree? You have any objection to that? Nothing else.
That is the reason, Lord.
But see, if the TP is from Assam, then you can, I'll provide for in the order, you can formulate a procedure wherein the TP will not do, there will also have to be a no objection certificate from you. From you or whoever is, because I will not allow you to.
But in that
have,
also,
no, I'm coming. I'll not allow you to keep the wagons pending. Anybody going there will have to go with all the documents required. You can also incorporate a NOC to that effect.
Supposed to be originating from Nanga. Because in some cases, Lord. Lordship,
We will provide it, or you give me a guideline. I am ready to accept this for this is a serious issue. No doubt about it. Meghalaya, Nagaland, we have Mr. Sharma, hear me out. Meghalaya and Nagaland, we are leaving it. They are gone. This will not cover. But if you want for TP from Assam to be make doubly sure, how do you do it? Because I'll not permit you to do it in the loading station. That will create a chaos. Railways will be left with no work.
the name of NOC, my lord.
It'll be no work. I'm not here running your office.
But Lordship,
Why should I run your office? Okay, anything more? So you agree that this will not be, this is only confined to the transfer permits it's called?
Transit pass.
Transit passes of coal originating from Assam, nothing. Mr. P. Sharma.
Instruction also, Lord.
Oh, yeah, I'm asking a statement. Mr. P. Sharma, Learned Counsel, appearing for the respondents. After arguing the matter at some length, or basing on instructions, has submitted that the communication dated 10/2/2022 is only be construed only to be issued in connection with the coal emanating within the state of Assam, and for which transit passes are issued by the Assam Mineral Development Corporation and or the department. They also issue?
Transit pass, my lord.
No,
Perhaps by
Okay.
tax department. My lord.
No. For which or originating within the state of Assam and sold by the Assam Mineral Development Corporation Limited. He submits that the said communication would not come in the way of free trade with regard to the coal admittedly originating from states outside other than the state of Assam. So, in view of the said conclusions, the petitioners have contended that this court would be pleased to dispose of the present writ petition. Hearing completed, registry to list this matters again on Thursday for delivery of orders. That was slip bonai delivery. So, issue resolved. Morning, I was trying to guide you to do that letter only. You should have only pointed that out. Oh. And I'm giving you,
Need to any record also.
Mr. I've recorded this, but I'm giving you another opportunity on Thursday if you want to make any further submissions for your benefit, commercial benefit of your organization. You can place it before me. Very good.